Good morning, everyone. It looks like we are streaming and recording. So I am now calling this evidentiary hearing to order. This is docket number 23 CONS 3080 CUIC. It's captioned in the matter of the application of Merit Energy LLC for a permit to authorize the injection of saltwater into the Morrow Formation at the WMSU number 1602 well in section 32, Township 34 South, Range 41 West, Morton County, Kansas. I am Andrew French, chairperson of the Kansas Corporation Commission. I'll be serving as presiding officer for this hearing, and I'm joined by my fellow commissioners, Commissioner Dwight Keene and Commissioner Annie Keither. We will begin the hearing with the entries of appearance, and I will start with the operator for Merit.
Thank you, Chair French. This is John Schlatter of the Morris Lang Law Firm on behalf of applicant and operator Merit Energy Company, LLC.
Good morning, Mr. Schlatter. And for staff?
Thank you, Chair French, and good morning, Commissioners. Kelsey Marsh on behalf of Commission staff and the public generally.
Great. Good morning, Mr. Marsh. All right, let's move to notice. Does staff have any recommendation regarding the notice of this hearing?
Yes, notice of this hearing was provided in the presiding officer's January 25th order setting evidentiary hearing for Wednesday, January 31st, 2024, beginning at 10 o'clock a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties. I would also note that Merit's counsel and witnesses are in attendance.
Any objection to notice of the hearing? Hearing no objections, I will find that notice is proper. The commission has jurisdiction over the proceeding at this time and place. Let's start with preliminary matters. As both parties have been here before, I will dispense with my own typical preliminary matters. Just remind everyone to mute their cell phones, other electronic devices, keep your microphones off or muted when you're not scheduled to talk. Do the parties have any other preliminary matters they wish to bring up? All right, I'm not seeing any, so we will now move to the procedure for the hearing. We are just going to use our standard procedure for this hearing. The parties will be allowed to make opening statements, then we'll have direct examination of the witnesses, cross-examination, commission questions, and then redirect for each witness. Further examination, as you know, will just be at the discretion of the commission, and we'll see how things go. Following examination of the witnesses, I will allow the parties to make closing statements if they wish to do so, and then we will conclude the hearing. So let us begin with opening statements, and we will begin with Mr. Schlatter.
Thank you, Chair French, commissioners. I'm going to try and use a couple demonstratives here through this opening, so bear with me here. It's just two diagrams, but I think it might help highlight what we're really talking about today, or at least what I hope we're talking about today. So when I get to that, I'll call them up and there'll just be a brief pause. So the procedural posture of this hearing today is somewhat unusual in my experience. We've already had the evidentiary hearing in this docket. My understanding is we're merely here today to supplement the record on reconsideration. And specifically, the commission has sought evidence on three, what I would characterize as relatively narrow issues, and those were set forth in the order soliciting testimony. One, the ability of operator to establish and adequately demonstrate future mechanical integrity at the WMSU 1602 if the application is approved. The type and frequency of chemical inhibitors anticipated to be used in the affectionately referred to dead zone, and whether evidence exists that such agents will be effective. And then lastly, whether there's any unacceptable risk of environmental harm associated with granting the application. Before I get there, I want to make sure we don't lose sight of the purpose of Merit's application. Merit seeks to duly complete the WMSU 1602 well for production of gas in the shallow Wabunzi Topeka zones, as it is currently doing, and also to inject into the Morrow, the deeper Morrow formation, to support the Wilborton Morrow sand unit to recover significant additional oil reserves. Now, there's no dispute that duly completed wells are allowed by commission regulations, or that Merit's application satisfies the requirements of those regulations. I don't believe there's any legitimate dispute that Merit's application will indeed prevent waste and protect correlative rights through continued gas production and recovery of additional reserves. There is no dispute that granting the application presents no threat to fresh water. I want it to be understood that Merit's not seeking an exception to any commission regulation or is asking for any special permissions. It's merely asking the commission apply its existing regulations to the application before it. Now, Merit's accommodated every legitimate concern staff has raised throughout this proceeding. It's agreed to perform a conventional pressure mechanical integrity test on the casing in the wellbore, both below and above the producing interval, which is plainly not required by the regulations. It's agreed to conduct a cement bond log to confirm that there is cement behind casing, as the commission's records indicate there is, which is also not required by the commission's regulations. It's also addressed a significant concern raised in the first hearing in this matter, and that's the so-called dead zone of the water column below the producing interval. It's re-engineered the wellbore design to reduce that dead zone by a factor of almost 90%. Notably, we spent a great deal of time in the first hearing on a specific interval behind the casing between 3,400 feet and 3,754 feet that staff believed was uncemented. As redesigned, the dead zone is now 900 feet below that interval, which completely obviates staff concerns in that regard. Nonetheless, staff remains opposed to this application. Merit has addressed staff's concerns, or as to other concerns, it's demonstrated beyond any standard of proof that those concerns are misplaced. Each time one issue is addressed, we seem to get another one pops up. It seems that staff is just entirely opposed to duly completed wells altogether. I think if that's staff's position, then it needs to go through the proper channels to amend the regulations to have them removed. I don't think it's proper or appropriate for staff to unilaterally delete commission regulations through this hearing process. That would usurp a legislatively prescribed rulemaking process that requires industry input and economic considerations. Reading between the lines here, I'm not sure we're not here to simply because staff wouldn't follow the commission's directive in its original order to work with Merit to come to an agreement on alternative methods to demonstrate casing integrity in the wellbore on a go-forward basis, and to come to an agreement with a chemical program. Now, whether I'm right or wrong there, I think circling back to the matters at hand, the evidence today will undeniably demonstrate that Merit can show the future can demonstrate that the mechanical integrity of the well can be demonstrated without a pressure test in the future, and that its chemical program is satisfactory to prevent corrosion through the growth of bacteria. On the point of mechanical integrity, all parties acknowledge that radioactive tracer testing will show that injected fluids are confined to the injection interval and that it's adequate to demonstrate the integrity of the tubing and packer at issue in the well. Staff's concern, as I understand it, is that the radioactive tracer testing is not an effective way to test the casing above the packer, and that the only way that casing can be tested is through a pressure test. I'm going to share my screen here. Okay, you should be able to see that. So the reason a casing pressure test is used on an ordinary injection well, such as this one, I note it says a space typical class 2 injection well, not a typical class 2 injection well. But the reason that a casing pressure test is used on these wells is because the annulus between the the production casing and the tubing is typically loaded with fluid. As you can see here, that's this interval. This is the same interval that's at issue in the case today, and it shows that the annular space is fluid filled. As such, the periodic fluid level and gas to water ratio monitoring prescribed by the commission regulations for duly completed wells would not identify a casing leak in an ordinary or atypical class 2 injection well because the fluid at all times is at surface. The static fluid in an ordinary injection well makes conducting a pressure test easy and inexpensive since it can be done off the back of a truck without a well intervention. They literally just pressure up on the backside and gauge to 300 pounds and confirm that the fluid's not lost. That's easy, that's inexpensive. In a duly completed well, such as the one Merritt is proposing, the annulus here is not loaded with fluid. That's not possible because the annulus is perforated for the production of oil and gas, in this case, gas. That's what these perforations are, which is how oil and gas wells work. The oil and gas flows through the perforations down the hole and are pumped to surface. This annulus has to be left open and not full of fluid so the well can work as intended. I believe this is why the commission regulations require periodic monitoring of fluid levels and gas to water production ratios as opposed to a casing pressure test. If there were a casing leak anywhere along the production casing here, fluid levels would rise and the ratio of water produced dramatically increased. In that case, a casing leak would immediately be identified. And this is how casing leaks are identified in all producing wells in Kansas. In this well, this shallow completion, which is the area at issue, is the producing interval, and it's an analog to any other producing well. On the contrary, a casing pressure test cannot be performed because of these perfs. If it were full of fluid, the fluid would merely migrate out the perfs, which is what the casing pressure test is identified to, designed to identify. The only way to do a casing pressure test in a duly completed well is to pull all of this stuff out of the hole, this string of injection tubing, this packer, this string of production tubing, and run equipment back in the hole on 2 occasions to test from this interval to this interval and from this interval up. That comes at an enormous cost to operator. And it's, it's not going unnoticed that staff's requirement is economically unfeasible. And it seems like kind of an end run way around to condemn the application. But what staff has not done and cannot do is explain why a conventional pressure test is superior than what Merritt is proposing in the way of, and what commission regulations require, which is periodic monitoring of the annular space and the production interval of the wellbore. I think the biggest benefit to this is it identifies a casing leak right away as opposed to every 5 years. And it goes without saying that a conventional pressure test is not designed to prevent a casing leak, but only to identify one. Second issue before the commission is the matter of treating the dead zone with chemical. Merritt will present expert testimony today as to why the chemical program designed by SGB Solutions is satisfactory to prevent corrosion in the wellbore, specifically to dead zone. The effectiveness and efficacy of this program will be proven through a 4-pronged monitoring approach that is prescribed by SGB Solutions. This testimony will go unrebutted. No person qualified to testify in the field of chemistry has been offered by staff. No plausible explanation has been offered as to why a program that works in thousands of other wells throughout Kansas would not work in this well. And the commission, I think, should defer to the experts in the field and the stakeholders most interested in preserving wellbore integrity. And so as to the final matter regarding any unacceptable environmental risk, I don't think any party to this proceeding has or will testify that the proposed application presents an unacceptable risk to the environment, and it's uncontested that the wellbore is engineered to prevent pollution of fresh water. So for these reasons, I believe the application should be granted. Specifically in any order granting the application, the chemical program designed by SGB Solutions and the alternative mechanical integrity testing method proposed by Merritt should be adopted by the commission. Thank you.
Thank you, Mr. Schlatter. Mr. Marsh, do you have an opening statement?
Yes, thank you, Chair French. As Mr. Schlatter previously stated, on September 14th, 2023, the commission issued an order soliciting additional testimony from the parties regarding three specific areas: the ability of operator to establish and adequately demonstrate future mechanical integrity of the well if its injection application is approved; two, the type and frequency of chemical inhibitors anticipated to be used in the dead zone and whether substantial evidence exists to find such agents will be effective; and three, any other testimony believed relevant to the question of whether there is an unacceptable risk of environmental harm associated with granting operator's application and or whether such risk can adequately be mitigated. Based on the testimony that's been provided up to this point, staff's position is that Merit has failed to provide an adequate way to demonstrate that the well has mechanical integrity. Staff also takes the position that Merit has failed to show that it can adequately treat the dead zone with the chemicals proposed in its testimony. If an operator cannot effectively demonstrate that it cannot mitigate these issues, which Merit has not, then the proposed injection application also presents an unacceptable risk of environmental harm, which Merit has not been able to show it can be properly mitigated. Thank you.
Thank you, Mr. Marsh. All right, I think we will have the applicant go first again. So Mr. Schlatter, you may call your first witness.
Thank you, Chair French. Applicant calls Kenneth Micah Moorhead.
Morning, Mr. Moorhead.
Good morning.
We are recording this hearing rather than having it transcribed directly. So I will be swearing you in. So if you would please raise your right hand. Do you swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Schlatter, you may proceed.
Thank you. Mr. Moorhead, would you please state your name for the record?
My name is Kenneth Micah Moorhead.
And you prefer Micah?
Yes, sir.
And for whom are you testifying in this proceeding and in what capacity?
Merit Energy, and I am currently employed by SGB Solutions, a production chemical provider.
And did you cause to have direct testimony consisting of 11 pages of questions and answers and an exhibit marked M11 to be pre-filed in this docket?
Yes, sir.
And did you also cause to have rebuttal testimony consisting of 5 pages of question and answers to be pre-filed in this docket?
Yes, sir.
And have you recently reviewed your testimony that was pre-filed?
Yes, sir.
And do you have any corrections to the testimony or your exhibit?
No, sir.
I would move that the pre-filed direct and rebuttal testimony of Micah Moorhead be admitted to the record in this proceeding.
Any objection?
No objections.
The described testimonies will be admitted.
And with that, I would submit Mr. Moorhead for cross-examination.
All right, thank you, Mr. Schlatter. Mr. Marsh, do you have cross-examination for this witness?
Yes, thank you, Chair French. Good morning, Mr. Moorhead.
Good morning.
I have a few questions for you regarding the testimony that you've filed in this docket. Now, you say that you're currently employed by SGB Solutions, correct?
Yes, sir.
Is Merit compensating you any way for the testimony that you are providing today?
Not a dollar.
Okay. But SGB Solutions has been hired by Merit to conduct extensive work on its production wells for the past 3+ years, correct?
Yes, we provide their chemicals. Yes, sir.
Okay. I believe in your testimony, you described that as a full service model.
Yes, sir.
About how much does that cost annually?
Annually, those costs, excuse me, so there's not a direct for this specific well. There's not a direct like chemical expenditure currently. So our services that we're offering to them for this would be looped kind of into the larger whole. Roughly for this area annually for this specific water.
We might be getting into some confidential information that I think either we need to go in executive session or evaluate the pertinence of this line of questioning. I just wanted to stop you right there.
Yeah, I don't know if it's, are you suggesting, Mr. Slatter, this would be confidential commercial information of Mr. Moorhead's company and their pricing?
Yes, sir.
Mr. Marsh, any response?
Well, I think the pricing's at least somewhat relevant as far as going towards Mr. Moorhead's credibility. But I don't know that I need exact numbers. I was just wanting a rough guesstimate.
Suppose we could stipulate it's probably substantial, considering the number of wells Merit operates.
That works for me.
Yeah, and I think it's going to be difficult for the commission to make a determination without knowing the exact number of wells I think if you all are okay with that stipulation that there's a substantial contractual relationship between the two, I think that's enough for me.
Okay, thank you. On Mr. Moorhead, on page 3, lines 1 through 4 of your testimony, you referenced the WMSU number 1107, correct?
Yes, sir.
And you state that that well had 10 corrosion-related failures in 2022.
Yes, sir.
Now the WMSU is or 1107 is a producing oil well, correct?
Yes, sir.
What formation is that well producing from?
I believe the West Morrow.
Okay. So it's not producing out of the Topeka Formation, correct?
That is correct, but it is also substantially corrosive, as its well history has shown.
Does SGB Solutions service any of Merit's injection wells?
Yes, we operate on several of their water floods. We're operate ensuring high injection water quality, low oxygen injection, and ensuring that the water is suitable for reinjection to not corrode downhole.
So you're testifying today that Merit does work, or not Merit, but SGB Solutions does provide chemical treatment for Merit's injection wells.
Yes, on some.
Can you point to the place in your testimony where you referenced that SGB Solutions services Merit's injection wells?
It is not there, but we do treat the water for reinjection.
Okay. In your testimony, you state that it is common for there to be 5 to 10 barrels of stagnant fluid at the bottom of a producing well, correct?
Yes, that has been my experience.
And you refer to that as a rat hole?
Yes, that was mostly to draw the distinction between two dead zones.
Gotcha. And how many rat holes have injection tubing going through them?
There would likely be none, simply because the injection is at the bottom of the well. But again, that's to tie between two dead zones, that the chemistry that we would use in one dead zone would be very similar, and the methods would be very similar to another dead zone.
But there is a difference, right, between a rat hole from a producing well and an injection well as this well would have?
There is a difference, but chemically and hydraulically, they would be treated very similar.
Okay. So if I asked you how many rat holes have injection below them, there wouldn't be any, correct?
Correct.
And whenever in your testimony, you said the modification effectively makes the subject well no different than the rat hole in about every other well in Kansas. I believe that was page 6, lines 5 and 6 of your testimony. You're basically saying that from a chemical aspect, not a mechanical aspect.
Correct. These dead zones would be treated no differently in the challenges that you would see in that rat hole area of stagnant fluid would be no different than this area of stagnant fluid.
On page 4, line 28 of your direct testimony, you state that the well bore as redesigned will not have the same barriers to treatment as producing wells have, correct?
Oh, what do you mean by barriers to treatment? In my testimony, I believe when they changed the wellbore design, there was not nearly the challenge because it's not as much fluid volume.
Um, if I can, I'm going to share my screen real quick, just so
No
that we're
problem.
on the same page here.
For sure.
So this is page 4, line 28.
Mr.
Before
Marsh,
that,
could you zoom in just a little bit? It's awfully small on my screen at least.
is that
Thank
better?
you. Yep, that's great. Then this is page 4 of Mr. Moorhead's direct testimony.
That is correct. So, Mr. Moorhead, you said that, under normal operating conditions, this area cannot be reached with conventional chemical applications because the downhole assembly and continuous production prevents the chemicals from reaching the rat hole. Notably, the subject well is redesigned will not have these barriers to treatment, which makes the application of chemicals more effective.
Gotcha. So that's in reference to typically, again, drawing the differences between the rat hole and the dead zone. In a typical rat hole situation, because it's below the pump, we would not be able to drop solid chemistries or do these things without removing the pump, removing tubing, because that fluid is hydraulically locked and there's downhole assembly in the way. With this, because of that dual completion, we can apply those solids chemistries, and they will fall to the bottom, reach that fluid, dissolve in that fluid, and treat, unlike a typical rat hole situation.
So even though this well still has a downhole pump, like a production or producing well would have, it's still different enough that you think it can be treated?
Yes, sir, because there's no there's fluid below that pump. We wouldn't, and an actual packer.
Well, isn't there fluid below the pump in a rat hole too?
There is, but the chemical is just going to come right up into the pump, and there's not really a space for us to drop solids chemistries, unlike this well.
Okay. Is there any risk of the chemical staying at the top and still just being pumped out without reaching the packer?
And not for the solids chemistry, no. And additionally, we're going to be applying the liquids chemistry with a side stream flush to aid in that chemistry falling.
Okay. Is the well going to be shut down whenever the solids chemistry is applied or the pellets are applied to the well?
It doesn't have to be.
Why not?
Because if we can either attach like a manifold to the casing to push those pellets down past that gas pressure, or typically during workover, we can apply it either way. So
Right.
that would also help when we periodically, I believe in there it's either monthly or once a quarter, I think initially monthly, coming in to reapply that pellet chemistry.
Moving on to, I think it's page 7, lines 16 through 19 of your direct testimony. You discuss a test conducted by a third-party lab, correct?
Yes, sir.
But you did not attach any test results to your testimony, is that correct?
I believe I submitted something that might not have been attached to the testimony, no.
And then on page 9 of your direct testimony, you state that monthly water samples will be collected, correct?
Yes.
Where will the samples be collected from?
From the tubing, the monitoring that we would produce fluid from the producing well. What we would be monitoring is iron and manganese counts as well as chemical residuals. The assumption being that the tubing is well protected from corrosion, so increases that we see in iron, manganese, or bacteria counts are coming from that dead zone, which then we would either reapply chemistry or make modifications to our application.
And I believe, whenever you talked about the iron and manganese levels, you said that you looked for it to be within a specified range. What is that specified range?
So typically for wells in this area, it's between 10 and 20 ppm on the iron counts. And then the manganese we want to have below a 0.8. Obviously, those are very, one thing we like about doing it that way is we have flexibility. So especially on these wells, we might tighten that range up a little bit just so we can keep an even closer eye on these wells.
And as part of the fluid samples, you mentioned measuring the residual concentration of the score dash 450.
Yes, sir. So that's oh, I'm sorry, go ahead.
Well, sorry, my question was going to be, what's the purpose of taking those residual measurements if the purpose of the score 450 is not to measure or treat the dead zone?
So we'll also be measuring, that's to ensure that the chemical's getting both down and around to ensure that it is falling to your previous point, but also to ensure that we can adjust ray if it seems like we're not getting a residual, if we need higher residual, to keep the downhole tubulars intact, or intact and corrosion free. So then we can ensure that any additional iron counts are coming from the dead zone.
Okay. Ms. Moore, I want to move on to some questions I have regarding your rebuttal testimony that you filed. On page 2, line 6 of your testimony, you state that the contested issue has never been whether the Topeka water is corrosive, correct?
Yes, sir.
Really, the purpose of this chemical treatment is to see whether the corrosive water in the well can be adequately treated, right?
Yes, and we've treated wells with these chemistries in the past of very similar chemical makeups and have had a good deal of success, as well as wells that are significantly more corrosive.
Now, you are aware that Mr. Lutsky has filed testimony in this docket, correct?
Yes.
Have you reviewed his testimony?
Yes, sir.
So you are aware that his position is that the Topeka is not a corrosive formation, correct?
I believe that was in speaking of having reviewed his testimony, it was more that it is not currently actively corroding based on the well treatments and the well corrosion history. And not that the water itself is uncorrosive, but that the corrosion is being controlled and maintained.
Okay, I'm going to pull up Mr. Lutsky's testimony. This is his direct testimony that he filed in this docket. There's a few portions I've highlighted. Mr. Moria, can you see my screen?
Yes, sir.
Okay.
Mr. Marsh, is this is direct testimony from this past December, or is this the earlier direct testimony?
This will be the original or earlier direct testimony.
Okay, thank you.
Page 6, line 10. Mr. Moorhead, does this line state, first, Merritt attempted to demonstrate that the water from the Topeka is not corrosive? Did I read that correctly?
Yes, sir.
And then later on lines 21 through 23, it says, additionally, the fact that the Pearson C2 has been producing from the Topeka since 1985 without damage to the casing demonstrates that the produced water is in fact not extremely corrosive. Did I read that correctly?
Yes, sir.
So he's not saying that it's not causing or currently causing corrosion. He's saying it's not corrosive, correct?
Yes, in that well bore.
But your statement is that this water is corrosive, correct?
It is corrosive if it is not treated, which is what they've been doing, I believe.
And didn't you say that the subject well has no history of corrosion over the past several decades?
I believe that is what was just read from the direct testimony. Yes,
Right. Have you been monitoring this well for the past several decades?
I have not, but Merritt has.
How long has Merritt had this lease?
Uh, I don't know that. I don't know how long they've had ownership of it, but according to that testimony, they have well pool records, and I've worked on other wells that we've seen extensive well pool records. So it would be something that they would be able to look up.
But you don't have personal knowledge necessarily that the subject well has had no corrosion issues over the past several decades, correct?
That is correct.
Um, on page 3, lines 26 and 27 of your rebuttal testimony, you state that the pellets will be dropped monthly to refresh the dead zone, correct?
Yes, sir.
Where will those pellets be dropped from?
From the casing, from surface into the casing
So how do you access the casing from the surface?
through
Which
the
that may not doesn't make sense, but is there like a latch or something that
there's a
Merritt can
valve.
open?
There's typically like a valve, like a 2-inch backside casing valve that any like our chemical would be going into, or we have like a little specialized pellet launcher where we can pressurize one side of it up to overcome wellbore pressure, casing pressure to push those pellets down and into the wellbore so they'll fall.
And I think in your rebuttal testimony, you say that there will be a batch application done quarterly,
Yes,
and that will remove any residual solids within the wellbore, correct?
that is correct.
What kind of residual are the residual solids the pellets that get stuck in the casing, or what are we talking about there?
So any kind of typically in these applications, it's any kind of like casing and tubing cleanup. So any kind of um, residual mineral scale that's formed or anything like that. Again, speaking in these chemistries, even the best of chemistries and the best applications are still only 99% effective. So there'll be that 1% of scale formation or that 1% that we are attacking with these batch applications. And if any, the odd pellet gets stuck or anything like that, it will sweep that away as well.
In your direct testimony, you state that the pellets are dropped into the casing once the tubing and pump have been removed. Is the tubing and pump going to be removed in this instance?
No, they wouldn't need to be to fall. This would be more towards the confusion between a rat hole and this application, because the rat hole sits below the pump. We would have to pull everything out, or the solids would just get sucked into the pump.
Mr. Moorhead, I next want to turn towards the chemical treatment plan or chemical recommendation that you attached to your testimony as Exhibit M11. Are you familiar with that recommendation?
Yes, sir.
Did you participate in creating that chemical recommendation?
Yes, sir.
So as we stated earlier, the purpose, I pulled up the chemical recommendation, and I also pulled up Exhibit M3, which was attached to Mr. Lahudsky's direct testimony, which was a water sample taken from the Pearson C2 back in December of 22. Now, Mr. Moorhead, as you previously stated, the purpose of this chemical recommendation is to attempt to treat the corrosive fluid in the wellbore, correct?
Yes.
And in this recommendation, it states that the Pearson C2 is currently producing 5 to 7 barrels of water per day, correct?
Yes, that was our understanding at the time.
And where do you get that number from?
Merit typically provides it.
You are aware that Mr. Lahutsky has testified that this well produces 3 barrels of water per day, correct?
If that is what the well produces, that would have minimal impact on the overall chemical recommendation.
What I'm curious is Mr. Lahutsky's numbers correct, or is the numbers that Merritt gave you correct?
I would refer to Mr. Lahusky's numbers.
So you have incorrect numbers in your chemical recommendation then?
Again, the main way that would influence the problem would be in an undertreatment situation. So typically, if we have lower production numbers, we would be over treating with chemical, which is not doesn't have an adverse effect to the well, but does have an adverse effect to our to the cost of the well. So that's really where that might be detrimental.
So once again, you have incorrect numbers in your chemical recommendation, correct?
Yes.
I'm going to lodge an objection. This testimony is from months ago. This is a current recommendation. This is not an apples to apples comparison. Everyone knows that wells go through a period of decline and changes in their anatomy. This could have very well been correct when Mr. Lahusky testified months ago when this hearing started, compared to when this was submitted to staff earlier this year or last year.
Well, then I think Mr. Schleider would have the ability to bring that up on redirect. I don't understand the objection here.
Well, you're asking someone that isn't testifying one thing about what one person knew. Maybe you should ask Mr. Lahutsky.
I'll let staff continue. I think it is an area that's ripe for redirect.
Mr. Moorhead, along the similar lines, the chemical recommendation states that the well is currently producing 35 to 40 metric cubic feet of gas per day, correct?
Yes.
But that number does not match the number provided by Mr. Lahutsky in his testimony, correct?
That is correct.
So once again, are the numbers in your chemical recommendation incorrect, or is the numbers in Mr. Lahutsky's testimony incorrect?
Again, those numbers wouldn't have much bearing on the effectiveness of the chemical program.
But can you say which numbers are incorrect or which ones are correct?
I cannot because it's not my well.
Okay. Going back down to the exhibit M3. In the chemical recommendation provided by SGB, it states that there is roughly 90,000 total dissolved solids, correct?
I believe so.
And I've highlighted that portion that says that there's 90,000 total dissolved solids.
Oh, sorry. My viewing window's in the way.
I can try to zoom in.
Oh, yes, there it is. Yes, sir. Yes, sir.
Start to lose a little bit there.
Oh, no, you're fine.
Looking at the water sample that was collected from the subject well, doesn't it say that the calculated total dissolved solids is 243,989?
Yes, sir.
So the number in the chemical recommendation is inaccurate?
That is correct.
In your chemical recommendation, you talk about specific gravity, and you say that there's a 1.06 specific gravity of the fluid. Why does specific gravity matter?
If the fluid is denser, the chemistries can have a harder time. That's why we went falling through. That's why we went with a solids chemistry. They can fall through even saturated brines.
And is that why? So you say that the CIP-25 pellets have a specific gravity of 1.2, correct?
Yes.
So what you're saying is since 1.2 is larger than 1.06, the pellets will fall through the fluid, correct?
Correct. Yes, sir.
Have you provided any product data that shows the specific gravity of the CIP-25 pellets?
I'm not specifically here. I believe it's in their SDS sheets.
But that's not attached to your testimony, correct?
Correct.
Looking at the specific gravity of the fluid in your chemical recommendation, it says 1.06, correct?
Correct.
But in the fluid sample that was taken, it says that the specific gravity of the fluid is 1.16, correct?
That is correct.
So the number in the chemical recommendation is inaccurate. Is that right?
That is correct, but the solids would still fall through a fluid of that density.
I happened to find and come across a product data sheet for the CIP-25 corrosion inhibitor pellet. Is that what that says at the top of this sheet?
Yes, sir.
Now I was interested in the specific gravity. Here it says that the specific gravity of the pellet is 1.048 to 1.096. Did I read that correctly?
Yes, sir.
So would that number be less than the 1.16 that is the specific gravity of the fluid in the well?
That would be less.
So in that case, the pellets would actually float in the dead zone, correct?
Based on those numbers, if that specific gravity is for the solid pellet and not a dissolved pellet, yes, sir.
I believe that covers all of my questions. Thank you, Mr. Moorhead.
Thank you.
Mr. Marsh, that last document that you published, is that an exhibit in the record?
It is not currently an exhibit in the record. I've identified that exhibit or potential exhibit as KCC supplemental -1. I mean, if the party's okay with allowing that exhibit to be admitted now, that's fine with me. If not, I will introduce it with Mr. Sullivan and have it admitted into the record at that point in time.
Okay, I mean, I think it probably needs some additional foundation,
Right.
because at this point we've just read some numbers off of it, and I
Correct.
would need to know, more for the relevance and foundation, as Mr. Moorhead pointed out. So we can just wait at this time for additional foundation. And did you indicate that had completed your cross, Mr. Marsh?
It does. Thank you,
All
Chair
right.
French.
Very good. At this time, we will move to any questions from the commissioners before we go to redirect. I will turn first to Commissioner Keen. Do you have any questions of this witness?
Yes, thank you. Thank you, Mr. Chair. Good morning, Mr. Moorhead.
Good morning.
If you would, just for the purpose of the record here this morning, just if you could very briefly provide us with an overview of your experience that's and your background that's relevant to the job that you now have.
Gotcha. So I was employed I've been in oil and gas industry for 12 years, all in production chemistry. I have a bachelor's degree from the University of Oklahoma in chemistry. I worked for Halliburton in the Multichem PSL for 9 years, and then SGB for 2.5.
Okay, very good. Thank you. Let's get a little generic, then we'll cut to the chase pretty quickly. For the benefit of the commission, virtually all oil and gas wells produce salt water, do they not?
That is correct.
And is it safe to say that salt water generally is corrosive to steel and steel pipe, indeed to most metals?
Yes, that is true.
And in terms of corrosiveness, and salinity. That salt water, there are different degrees of salinity, are there not?
That is true. Yes, sir.
So, correct me if I'm wrong here, but doesn't it become now a question of whether it really isn't a question of whether saltwater is corrosive, but whether with respect to saltwater corrosiveness, the core issue, it strikes me, becomes how and to what extent is that corrosiveness capable of being mitigated and managed? Isn't that correct?
Yes, sir.
That's a major part of your job, isn't it?
Yes, sir. And that
I didn't
is.
mean to
I'm
interrupt.
sorry. Oh no, you're fine.
No, please go ahead and answer. I think I interrupted your answer to the previous question too. Go ahead,
No,
please.
that is what the corrosion inhibitors and the different chemistries that are out there are designed to do exactly that. Brine is corrosive. The higher salinity accelerates corrosion and the corrodants in that brine. And those inhibitors are designed to slow that corrosion down to a very, very minimal state.
And the operator, whomever the operator may be, whether it's Merit or any other operator, has a vested interest, do they not, in having a chemical program that treats corrosion to reduce operating costs and expenses.
They do, yes, sir. Some operators don't treat for corrosion even in higher salinity wells. It's kind of just based on the history, based on those well histories and other corroding factors in those well bores.
Okay. You alluded to iron and manganese levels. Correct me if I'm wrong, because I need to lean on your experience, which is, I think, rather substantial here. These are basically some evidence of corrosion, are they not, or the corrosiveness?
Yes, sir.
That's what you're measuring, isn't that correct?
Yes, sir. So typically, iron can be naturally produced, manganese only in a few select formations, which this is not one of them, is produced. That is essentially what we're measuring. Is the goal would be, as we apply corrosion chemistry, the iron to manganese rates would decrease, and if the iron to manganese rates are high, that would be where the assumption is that the majority of that manganese is coming from the alloy of the steel, and the majority of that iron is coming from downhole tubulars.
Even I understood that. That was pretty good. Thank you.
I do my best.
So in terms of monitoring for these different levels of corrosion, or these corrosion characteristics, do you use coupons in that process?
You can, yes, sir. The issue with coupons and why it wasn't something that was suggested in this well is they only measure the fluid that is passing by them. So they would not, you could get a general sense of what the corrosion rate was on the fluid passing by it, but not of what was at the dead zone. Whereas those ions would eventually carry out of the well and we could measure them.
That's very good.
But we 100% on several of Merit's locations at the WMSU utilize corrosion coupons.
Okay. So basically, I'm going to kind of be generic here for the benefit of all of us, and most importantly myself. Your intention here was to use the pellets, because they're solids and they're going to fall through liquids, to treat the dead zone. Is that correct?
Yes, sir.
And to basically use the liquid chemical treatment, the other chemical treating compound that you're going to use to treat rods, tubing, and pump. Is that fair?
Yes, sir.
Because you're concerned about not just treating the dead zone, you're concerned about corrosion throughout the entire internal construction of the well, in the best interest of the longevity of all of those steel components, so that it doesn't become an excessive cost center to the operator. Is that correct?
That is correct. Yes, sir.
seemed, and I was kind of picking up in Mr. Kelsey's questions of you, some question about how in the world you get it from the surface down to the base of the well. Describe that very briefly for me, if you would. I think most wells have well heads, do they not?
Yes, sir. So there would be a wellhead, and typically there are um, varying sizes, 1 to 2 to 3 inch valves on the casing side that we would attach a manifold to we call it a launcher to launch these pellets through. The liquid chemistry would also be applied via the casing through a side stream flush. What that does is it takes a little bit of the produced fluids, pushes it back against the chemical injection, so then it has a little additional fluid to push that chemistry down. To Mr. Marsh's questions, he's exactly correct that in some instances, if the casing pressure is high enough or there's enough gas velocity, the chemical will just come right back out. And so that's why we want to apply the chemistry in these ways. And that's why we selected solids chemistry to fall to the bottom.
Okay. So back to the wellhead, and we'll finish that and move on here pretty quickly. We have some access ports, usually either set on at least 2 sides of a casing head, do we not?
Typically, yes, sir.
Yeah, it's going to provide you access basically to the annular space, which is the space between the inside diameter of the casing and the outside diameter of the tubing, be there 1 or more strings. And that's going to give you an opportunity really to actually treat from the surface. Isn't that correct?
Yes, sir.
With respect to the use of pellets, by what method can you what method can you use to tell us give us some assurances that these pellets will actually reach the dead zone from the surface?
We can measure the quat residual as that it kind of osmosis up. Additionally, we can run tests to excuse me, ensure that the pellets will fall through the fluid brine. That's a fairly simple test to run. As far as we should also see an increase in the chemical residual numbers as those pellets dissolve.
So basically, through these various techniques you've just described, you'll be able to determine whether the pellets have actually reached the intended target, which is the dead zone, and they're not just floating. Isn't that correct?
Correct. We'll also see one of the things we would measure is bacteria concentration, and that would be one of the leading indicators that there was a concern in the dead zone.
Okay, let's move on. I'm nearly finished with my prompts for you. John, if you would be kind enough, could you put up, please? Let's turn to Mr. Sullivan's supplemental testimony of January 18th, 2024. I'm on page 6, please.
One moment. I believe this is it, Commissioner Keen.
That is it. Thank you very much, John. Mr. Moorhead, let's take a look, if we can, to lines 4 through 6. And let me read what I think is germane here. John has just highlighted it. It says, even if the CIP 25 pellets reach the stagnant fluid column, I have not seen any documentation indicating that the pellets will completely treat the produced fluid above the packer. I would really appreciate having you respond to this.
Okay. So the pellets are made of a chemistry, I believe I put it somewhere in my testimony, of a quaternary ammonium compound, specifically a DDAC quat. These quats have been a pretty common oil field chemical technology for the last 30 or 40 so years. In high enough concentrations, they will act as corrosion inhibitors. And when I say high enough concentrations, typically the EPA uses a DDAC quat as a biocide, typically in concentrations between 10 and 30%, 10 and 30 parts per million for surfaces. And like if you look at your Clorox wipes, you'll see that they have DDAC quat in them. At higher concentrations, that quat acts like a filming amine. So we did not provide direct documentation of the exact testing, similar like in my previous testimony talking about the 1107. For that reason, it was something that when these pellets are applied, they're going to be applied in several thousand ppm of active corrosion inhibitor and active chemistry downhole, which is significantly orders of magnitude more than what we would test. Again, it kind of falls back to if we were optimizing this from a service standpoint, we would want to find the optimal balance of maximum corrosion inhibition at the smallest concentration possible with this dead zone, because we're able to kind of over-treat it in this way at fairly low economic cost. We can really ramp that up so that we know that we're getting effective treatment.
Okay, very good. I appreciate it. Appreciate your responsiveness to my questions. One final question for me. Mr. Moorhead, in preparing to testify this morning, have you had the opportunity to review Mr. Kenny Sullivan's supplemental testimony that has been filed in anticipation of this hearing?
I have not reviewed it this morning, no.
No, I'm not saying this morning. Have you reviewed it prior to this morning?
I believe so, yes, sir.
Yeah. The question I have for you is, he's very critical in several respects of the chemical plan that you have. My simple final question to you was, have you assessed this testimony and its conclusions?
I believe we have. I believe coming back with the monitoring, it seems like the main kind of drivers of this are corrosion control and ensuring that there's downhole and wellbore integrity, and the monitoring and measuring that we're doing picks up on those things. And if we see something that falls out of our specifications, we can quickly make changes, make modifications well before there's any concern or any kind of corrosion related issue that crops up.
Thank you very much, Mr. Moorhead. I appreciate your indulgence of my questions. I have no further questions of this witness. Thank you.
Thank you, Commissioner Keen. Commissioner Keither, do you have any questions?
Not at this time, thank you.
Thank you. I think I have one question, Mr. Moorhead. Good morning.
Good morning.
And it's a very general question. In looking at the redesign of the well, well, it's described at page 6 of Mr. Lehutsky's supplemental testimony, but you need not go there. But he talks about how there was a major issue in the first part of this proceeding about how large the dead zone was, that I think it was over 1,500 feet, and that at one point it would be there would be some stagnant fluid sitting against a portion of production casing that was uncemented, but that a major difference now is it's been narrowed down to 168 feet, and that there wouldn't be any stagnant fluid against an uncemented portion. At least that's my understanding. Did that change the chemical treatment plan that you had to put in place, given that it seems like it's only up against cemented portions of the casing at this point? How did that impact your recommendation?
So as far as the impact of cement, the chemistry doesn't really do anything for corrosion or breakdown of cement. It would only be for pipe steel or different steel metallurgies. Um, but as far as the change, that definitely you know the efforts made by Merit definitely improved those outcomes. Less dead zone, less fluid to treat. We can use the same amount of chemistry, get a higher concentration. Um, and to some of my points with Commissioner Keen, increase that parts per million and really ensure that we can drive that corrosion rate as well as any kind of bacteria concentration down as low as possible.
So the fact that it's not up against an uncemented portion now doesn't change the chemistry work that you want to do. It just mitigates the chance that it ever hits an uncemented portion and corrodes against steel or something that might be impacted, because you're only talking 168 feet of that you might have a leak or an issue where it could get at that casing. Is that right?
I believe if I'm understanding you correctly, yes, it would increase the because there's less fluid we have to treat. It increases the concentration of the chemical dispersed therein, further driving the corrosion rate down so that the steel never, is corroding at an incredibly low rate. So it never, even if regardless if there was or wasn't cement, it wouldn't be an issue. Typically, when we provide chemical recommendations, from a chemical company standpoint, where cement is, what the bond logs are, things like that. That's something that is either information that is not given to us, or is just simply outside of what would be required to effectively treat the corrosion in the wellbore.
So when you're coming up with a plan, do you just operate on the assumption that there may be an issue with the cement? And so you want to make sure you've got the corrosion inhibited to the extent there is an issue with the cement?
Absolutely. And my goal is my program has failed if there's a hole in the tubing or the casing. So that is my primary goal in any application that we're doing, is preventing that steel corrosion. So whether there is cement, there isn't cement, what the situation is behind that, we're making sure that a hole never appears.
Okay. Well, I appreciate you sticking with me there. I was just trying to get a basic understanding of what we're talking about, and I think you've got me there. So I appreciate it. I don't have any further questions. Mr. Schlatter, do you have any redirect?
Real brief, Chair French. Mr. Moorhead, just a couple questions here. During Mr. Marsh's cross-examination of you, several discrepancies were identified between a December 2022 chemical analysis by SGB Solutions that was Exhibit M3 to Mr. Lahusky's testimony, and the August 2023 chemical recommendation from SGB Solutions as Exhibit M11. My question to you is, would any of these minute discrepancies cause you to change your chemical program one way or the other?
They would not, based on the chemistries that we have running, have been shown historically to be effective in brines, significantly higher in TDS and chloride concentrations than what is being produced here. And the concentrations that we're running are, as I previously stated, significantly higher than what would even be required from testing. So no, that would not change my application.
In your experience, that application would be effective?
Yes, sir. We've not only treated several of Merit's wells, but many other operators in a similar manner.
And the water chemistry of this well isn't some magical unicorn. It's common in this particular area.
particularly, yes, sir, in Kansas, the chloride concentration of that, the TDSs that's fairly in line with a lot of Kansas producing wells.
Thank you. That's all the questions I have.
All right. Let me ask, I think we've come to a conclusion of this witness. And Mr. Moorhead, you may step down virtually. Mr. Schlatter, let me ask you though, to the extent we need any clarifications from your witnesses, do you know if they intend to be available throughout this hearing, even after they're released?
They will do as the commission directs them. Yes, I anticipate they'll be observing staff's testimony.
Okay. Okay, thank you. That's just good to know, just for planning purposes. To the extent something comes up and we need clarification, we may have the availability to ask those questions. So appreciate that. You may call your next witness, Mr. Schlatter.
Thank you, Chair French. Applicant calls Mr. Nick Lahutsky.
Good morning.
Good morning, Mr. Lahutsky. If you would please raise your right hand. Do you swear or affirm the testimony you are to give today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Schlatter.
Thank you. Mr. Lahutsky, could you please state your name for the record?
Hi, my name is Nicholas Lahutsky. I go by Nick, and I'm a senior reservoir engineer at Merit Energy.
And did you cause to have direct testimony consisting of 7 pages of questions and answers and an exhibit marked as M10 to be pre-filed in this docket?
Yes, I did.
And did you also cause to have rebuttal testimony consisting of 11 pages of questions and answers to be pre-filed in this docket?
Yes, I did.
And have you recently reviewed this testimony that you pre-filed in this matter?
Yes, I have.
And do you have any corrections or changes to that testimony?
Do not.
Yeah, I would move that the pre-filed direct and rebuttal testimony of Nick Lahutsky be admitted into the record.
Any objection?
No objections.
Hearing none, the referenced testimonies will be admitted into the record.
Thank you. I would tender this witness for cross.
All right, thank you. Mr. Marsh, do you have cross-examination for this witness?
Yes, thank you, Chair French. Good morning, Mr. Lahutsky.
Good morning.
Like Ms. Moorhead, I have a few questions regarding the testimony that you filed in this docket. In your testimony, you state that this is an application to duly complete the subject well, correct?
That is correct.
But really, this is an application for an injection well, right?
This is an application granting the right to inject into the Morrow zone as part of a dual completion.
And as part of that, the well is required to meet certain regulations for injection wells, correct?
Correct.
And as part of this injection well, Merit proposes to inject through tubing below Packer, is that correct?
Yes.
Are you aware of the commission's regulations regarding tubing and Packer requirements?
I believe so.
So you're aware that a Packer run on tubing has to be set in casing opposite a cemented interval at a point immediately above the uppermost perforation or open hole interval?
Yes.
And you're aware that the annulus between the tubing and the casing shall be filled with a corrosion inhibiting fluid or hydrocarbon liquid. Is that correct?
For a single completion well, that sounds correct, yes.
Why would that not apply to this well?
As stated by Mr. Slaughter in the opening statements, if you've got a producing completion, then inherently that completion cannot be filled with liquid.
Is there anything that says that duly completed wells are accepted from the tubing and Packer requirements?
Duly completed wells, there's a portion of the regulations that specifically state how they are to be built. So
But I was asking if there's anything that accepts them from tubing and Packer requirements.
not to my knowledge that directly states that statement, no.
I want to move on to your supplemental direct testimony. On page 2, lines 23 through 25 of your supplemental direct testimony, you state that Merritt sought confirmation from staff that radioactive tracer testing would be acceptable way to demonstrate mechanical integrity of the subject well, correct?
Yes, we have sought that confirmation.
And on page 3, line 11 of your supplemental testimony, you state that staff never responded or made any effort, correct?
There was no effort, meeting, or dialogue between Merritt and staff on finding an acceptable alternative MIT test as directed by the commission after the first hearing.
How many times did you personally reach out to staff regarding the MIT after the first hearing?
Don't know the exact number, but I reached out and tried to leave a voicemail with Mr. Todd Bryant more than once, as I recall, and never received a return call. And we have a regulatory specialist at our company, Miss Kathy McClurkin, and she's also reached out as part of this application as well as Mr. Slaughter reaching out, trying to organize meetings.
Do you have any records of those phone calls where you reached out to staff?
I'm sure we could find them, but they were not submitted as part of this testimony.
Okay. And you were already aware that staff had opposition to the radioactive tracer surveys, correct?
Yes, that was expressed in the first hearing.
Right. So if you already knew that staff was opposed to radioactive tracer surveys, then what is there really for staff to respond to if Merritt's only proposal was to do a radioactive tracer survey?
Well, the radioactive tracer survey is only a portion of the proposal. And the portion of the proposal is to establish mechanical integrity of the injection tubing, the packer, as well as to measure where the injected fluid's going. So from that perspective, we do think that staff has testified that it can be done that. Now, the rest of the mechanical integrity portion, which is the establishment of mechanical integrity of the casing, we do need to find an alternative solution on, and we're not proposing that the radioactive tracer solves that problem. So it's a part of a bigger pie, is what I would answer.
Did you express that whenever you attempted to reach out to staff?
Had we been able to have a meeting or dialogue, I would have.
You later state in your testimony, I think it's page 5 verses 15, lines 15 through 17, that Ken Jelly from District 1 and representatives from Merritt and SGB had a phone call to discuss the chemical program, correct?
Yes. So I was not a part of that meeting, but related to the chemical program, yes, there was discussions on that.
So how do you know the meeting occurred if you weren't part of it?
I believe Mr. Moorhead was part of it, as well as another engineer at Merritt.
Who was the engineer from Merritt?
His name is Keaton. Look up his last name. But he was a part of it, and I have records that they spoke.
But you never reached out to staff directly regarding the chemical program?
I did not reach out to Mr. Kenjelic related to that program, but
did you reach out to anyone else from District 1 staff or central office staff?
Not me personally. That was part of why we have Mr. Moorhead helping us out on this application, though.
On page 5, lines 20 through 27 of your direct testimony or supplemental direct testimony, you discussed that the wellbore construction changed by adding a siphon string below the pump, correct?
Yes.
Does the addition of the siphon string rely on an effective chemical treatment program to be fully effective?
No.
And you later state that Mr. Jellick agreed to the wellbore construction change?
I actually believe it's his idea as it was communicated with me. And I think it was a great idea, which is why we accepted it.
But you weren't part of that conversation, correct?
No.
Have you attached any documentation showing he agreed to the siphon string as part of your testimony?
It was part of the testimony. Is that the documentation?
Any documentation besides that? Any communication from Mr. Jellick saying that he agreed?
No. We have an email that was sent to him, but he never responded to it after the phone call.
Now, as you've repeatedly stated in your testimonies, you state that a radioactive tracer is specifically identified as an alternative test method to establish mechanical integrity, correct?
Yes.
And doesn't the regulation state that it's acceptable when the conditions are appropriate?
Yes.
I want to move on to your rebuttal testimony. And we've already talked about it a little bit today, but in previous testimony, you've said that the Topeka is not corrosive, but if the Topeka, my question is, if the Topeka is not corrosive, then why is it being treated by merit?
Yes, so that seems to be a discussion point today. So if you look through the testimonies that I've submitted, as well as the testimonies Mr. Moore submitted, the Topeka corrosion is brought up probably in all of them, at least once. Have to review it specifically. And the theme of all of those testimonies is the same, that the Topeka has been completed in the Pearson C2 well since 1989, and we have not had any corrosion-related failures or problems within that wellbore since then. Now, the word corrosion is not a light switch that turns on or off. It's a spectrum, how fast things are corroding. And so when you're defining things in terms of corrosive versus not corrosive, that language probably doesn't well describe the situation. And I will defer to Mr. Moorhead for the technical matters of that, but I don't think saying that things are not corrosive or corroding in present tense is the same as saying not corrosive at all in a no shape or form causing corrosion.
So you would agree with Mr. Moorhead that the Topeka is a corrosive formation?
Yes.
So any testimony that you previously had saying it wasn't corrosive is inaccurate and should have been not currently causing corrosion?
I would say that that falls within the gray area of defining corrosion. If it's not currently happening, then it's not really corrosive in practice. But if you're going to have some very specific language, then the brine has the potential to corrode at all times.
Okay. On page 2, line 25 of your rebuttal testimony, you state that the monitoring and reporting requirements prescribed by the regulations were intended to replace the conventional pressure test, correct?
Yes, I believe that to be true.
Did you participate in the rules and regulations drafting process?
I was not part of that drafting process.
Have you conducted any research where intention was clearly laid out?
Only in reading the regulations.
So you haven't done any research beyond just reading the regulations?
And understanding them, yes.
So really it's your interpretation, not this is what was intended.
That's what I believe, yes.
On page 3, line 11 of your rebuttal testimony, you talk about a tortured interpretation by commission staff. What do you mean by that?
Can we pull it up so I can see the context?
Yeah. Let's see. 1 second, please. If anybody else can get to it quicker than me, please let me know.
I'm sorry, Kelsey, are you almost there?
I'm working on it.
And what are you looking for again?
I think it was page 3, line 11. Yeah, I got
the
it.
rebuttal
Of
testimony.
the rebuttal testimony. I've got it.
Okay.
I'm looking at it right now.
Do you need me to zoom in anymore or anything like that?
I can see that. New reasons to post applications and concerns. So that statement looks like it's directly referring to the topic of continuous cement behind the casing. And we discussed this at length in the first hearing. Is the language referring to continuous cement between the zones continuously, or is it continuous cement across the perforations? And I do believe that staff interpreted that one way and the commission did order in a different way on that matter.
And staff's interpretation was tortured.
Yes.
On page 3, lines 24 through 25 of your testimony, you state that the commission directed staff to work with Merit to finalize conditions for permitting the subject well for dual completion, correct?
Yes, I believe that was the order after the first hearing.
But there was also part of the ordering clause that said if operator is unable to meet the conditions identified in ordering clause A, or if operator and staff are unable to reach agreement on the items identified in ordering clause B, or if any additional issue arises not contemplated by this order, then parties are directed to bring the issue before the commission for further consideration, correct?
Correct.
Which is what we're doing here.
That is what we're doing today, yes.
Okay. Mr. Lahutsky, how would you define the word may?
May.
May.
That would be permitted to, but not required. Maybe that's a good description. Permitted to
And just
accomplish
that,
the task, whatever it's referring to, but not necessarily required to at maybe the pretext of the subject.
so just to add context, ordering clause B of the commission's final order said that to reach general agreement regarding alternative test methods to establish future mechanical integrity with the idea that the radioactive tracer method may be appropriate. So what you're saying is, permissible, but not necessarily required, correct?
Yes.
I believe it's, let me. On page 4, lines 25 through 28, you state that Mr. Sullivan and Mr. Clark have acknowledged that the tracer survey is an effective way to show that the packer and tubing are mechanically sound, correct?
Yes.
Where do they say that at?
We can take a look at Mr. Sullivan's testimony. I believe that is one of the places that is stated.
Mr. Sullivan's testimony.
Is there a question before the witness right now?
Yeah, we're at in Mr. Sullivan's testimony. Did he say that?
I believe I have it pulled up right here. On page 3 of Mr. Sullivan's testimony, lines 7 through 9, he states, beginning of a sentence, a radioactive tracer might show an issue with the packer and or tubing, but would not be able to show an issue with the casing, as it does not test the casing of the wellbore. And so my statement in the testimony is stating that Mr. Sullivan has testified that the radioactive tracer could show an issue with the tubing and packer, but not the casing.
I believe in your testimony, you said it's an effective way, but just based on the testimony that you just read, he said might, correct?
He did use the word might.
So that's not necessarily definitive, is it?
It is not, but I do believe he was agreeing that the radioactive tracer has value added. There's a reason it's specifically mentioned in the regulations as an alternative mechanical integrity test.
Going on to page 6, lines 1 through 5 of your supplemental rebuttal testimony, you state that a conventional pressure test would pose a significant operational risk, correct?
That is true. The conventional pressure test that's been recommended from, I believe, Mr. Sullivan and was it Mr. Clock, the other one of the other testimonies. I could describe, just answer yes.
However, Merit has indicated that it would be willing to conduct conventional pressure tests on the subject wells every 5 years, correct?
Not every 5 years. That is, I mentioned that in my testimony. So we have agreed to conduct a conventional pressure test at the time of initial completion. That was also one of it was mentioned specifically in the order that the application would be approved if we did that conventional pressure test and that it passed. But subsequently, every 5 years, no, to rig up on the well, remove all of the equipment, get rental packers and bridge plugs and run tubing and test the zones separately would be out of the ordinary costs and would make this project not worth it for us.
I'm going to share what has previously been admitted into the record as Exhibit M4. I've highlighted a portion here that I'm going to read to you. It says, alternatively, if it would make staff more comfortable, Merit would be willing to conduct conventional pressure tests on the every 5 years. Did I read that correctly?
Yes.
So Merit has previously indicated that it'd be willing to do a pressure test every 5 years.
I believe that mitigation plan was submitted very early in the process, probably in the calendar year 2022. And we have decided that that would be an excessive cost since then. If I believe that's what's going on there.
I believe in your testimony, and I think it's still that same location of page 6, lines 1 through 5 of your supplemental rebuttal testimony. You state that a pressure test can only identify a casing leak. It cannot prevent one, correct?
That is true, yes.
How does a radioactive tracer survey and either fluid or gas monitoring prevent a casing leak?
They also just measure for casing leaks.
So it's not really any different than doing a conventional pressure testing.
No, there are alternative forms of mechanical integrity test.
If a pressure test was conducted and performed once every 5 years at a pressure lower than what is being injected into the well daily, then how is the risk more significant?
The risk being discussed with the conventional pressure test is the risk associated with an intervention in the well, which is removing all of that equipment, allowing the zones to cross flow and working on it in general. That's operational risk. It's not, I'm not sure what risk you're referring to. That's the risk that I was mentioning, though, referring to.
Okay. Now you talked about cross flow of fluid, but you've testified that the shallow gas zone will not be irreparably damaged by that cross flow, correct?
I do not believe it will be irreparably damaged. That's correct.
So then what's the real risk of doing a pressure test?
Well, there's risk associated with removing the tubing in and out of the well every time you rig up and start. It takes a long time to remove that tubing and that packer, as well as running a new string to test all of that equipment. And you're moving a lot of things around, and that movement can cause wear and tear on everything inside the wellbore. So that's the risk that I'm talking about. The risk associated with crossflow is a little different. It is talking. So one of the themes that we discussed in the last hearing and was also present in Mr. Sullivan's testimony before this hearing was that crossflow would be, I don't know what the right word is, but irreparably damaging to the Topeka. So that risk would occur while we were doing a conventional pressure test, because when we remove the injection packer, then those two zones would be allowed to commingle. And so to the extent that someone believes that the crossflow should be mitigated, you are adding risk to the wellbore when you're intentionally allowing the crossflow to occur.
But you say in your testimony that that risk shouldn't cause irreparable damage or can't be overcome, correct?
No, I don't believe the damage would be irreparable. You would suspect that the water production rate from the Topeka would be increased for a period of time after the crossflow occurred. But once that water was produced back out of the formation, then I believe the production rates of the well would go back to what they were before the test was occurring.
Does casing stay sound over time, or is it constantly under the threat of deterioration?
Casing, steel, and generally speaking, steel is always deteriorating. So it is.
And that's the purpose of the chemical treatment plan described by Mr. Moorhead, correct?
Yes, the purpose of production chemicals, which is a loose term that we use to define, all of the chemicals that we add to our process streams or wellbores, is one of their responsibilities is to reduce that corrosion rate.
On page 8, lines 8 through 9 of your supplemental rebuttal testimony, you state that staff's position that the Gore D number 2 watered out after the dual completion was subsequently disproven by the commission's own records, correct?
Yes.
Which commission records are those?
So those were submitted as Exhibit M9, additional Gore D2 completion records. And there were some well tests that are required on gas completion zones that were submitted after the dual completion date. And those well tests indicated open flow. The point of them is to calculate open flow gas production rates. And those numbers were above zero. And the theme of the theme of the staff's testimony was that because there was no production data found associated with the API and KGS, that proved that the Topeka was permanently damaged. And so using those well tests, which are public record documents, I believe that I disproved that the wellbore was permanently damaged.
Okay, I'm pulling up exhibit, I believe it's M7 that was attached to your direct testimony or initial direct testimony.
Correct.
And is this the well record you're referring to?
So that was the one that we submitted before the first hearing, but then there's another exhibit that's additional completion records, and that's what I'm referring to now. So that would be after M7.
Sorry, just to help this clarify what you're talking about. He's referring to the records attached to operator's response to the petition for reconsideration as Exhibit B. It has the open flow test showing that well produced gas.
Mr. Slaughter, if you have that available, we
I
could
do.
pull that up and I could
Yeah.
show you.
I want to ask one question about this record first, if I may.
Sure.
It says productivity record. It says CAOF 2505. Do you know what CAOF stands for?
I believe it stands for calculated open flow.
Right. Calculated absolute open flow. So that's a calculation, correct?
That is a calculation, yes.
And it's just an estimation.
It's an extrapolation of actual measured data.
And
So-
under current production, there is no current production for the well, correct?
Yes, and I can answer why. It's also included in the subsequent records. The gas line to the backside was not installed until March of that year. So the work was done, then a calculated open flow rate was completed, and then it took 2 months for the infrastructure, the well, to be connected to the infrastructure, and then at that time, the well was opened up and turned on production.
If the well was capable of such production, then why are there no production records showing there was actually gas sold?
Also included in the additional records, the well was linked to a pool of, it was either unitization or a producing operating pool. So the gas production from this well was sold along with gas production from other wells as a common pool. And when that occurs, sometimes the production is not linked to the specific API in KGS. Basically, I'm just saying that those records are not wrong. They're just occasionally missing information.
And there is no records that show that this well, this record doesn't show that there was any production after the well was duly completed, correct?
That record does not show that there was production associated with this API after the dual completion. That is correct.
And then this record, which is also the same well, doesn't show any production until after it was recompleted in the chase zone, correct?
Yes, after 1994 was when the dual completion was. They plugged off both of the zones and came up higher.
Okay.
And chase.
And Mr. Schleier, what was that exhibit again? Or where's that record? Sorry, you're on mute.
Thank you. Here, I'll put it up. I think I know. This is operator's response to staff petition for reconsideration. And then if you scroll down to Exhibit B, there's numerous pages of what are they, old school open flow tests, I believe.
So that's the test right there that resulted in the calculated open flow test of, I think it was 2505. So you can actually look at the different measured producing rates that exist, and then the 2505 is an extrapolation of those rates.
Is there any KGS records attached to this showing that there's production?
I believe that KGS record showed there were 2 wells there. Basically master meter. Here's another one.
The stamps on these records are State Geological Society. Is that like the same as KGS, just a precursor?
It's probably where they're archived, which is, yes, it's the same entity, Kansas Geologic Survey.
And I guess if I had a question at this point, it'd be there's no KGS records attached to Merit's response to the petition for reconsideration, correct?
There's KGS, there's State Geological records in this attachment that we're looking at. So if you can scroll down.
There's not any production records like the one that I pulled up earlier from the KGS website.
No, there's no historical production records. I was looking for specifically for documents that exist in the public realm, and so those well tests were the best thing I found.
Okay.
You want me to Do you want to go through this exhibit or do you want me to stop sharing it?
I don't know that I need to go through it. Thank you, Mr. Schneider. Or if I want to go through it, I got it pulled up, so I'll glance through it. Mr. Letsky, do you agree that staff cannot permit the subject well until Merit has provided staff a current cement bond log that verifies the well is constructed as Merit has claimed?
Yes, I do agree that.
What happens if the cement bond log shows that there is insufficient cement behind the casing?
So we would have to understand what is sufficient cement behind the casing. And as I believe it to be true, or would expect staff to agree with, is that sufficient cement behind the casing is cement across the perforated intervals in excess of 100 feet in each direction. And I do believe the bond log will show that when we run it. We discussed this in the first hearing. We've offered to run the bond log, but as part of a design approval or conditions of approval of this permit, if the bond log was what was preventing us from having an approved permit and everything else was agreed upon, then we're willing to run it. But right now, we do not have assurance that that bond log is going to change staff's position on this permit at all.
I know I'm asked Mr. Moorhead some questions about the chemical recommendation and some inconsistencies in the numbers between your testimony and the numbers that were provided by Merit to Mr. Moorhead for his chemical recommendation. You were present whenever I asked him those questions, correct?
During the cross-examination with Mr. Moorhead?
Yes.
Yes, I was present.
Okay. And you're aware that the chemical recommendation, the numbers that Merit provided were 5 to 7 barrels of water per day, but your testimony states that there's only 3 barrels of water per day produced.
Yes.
Speaker, correct?
Yes.
So whose numbers are accurate? The numbers that you gave in your testimony or the numbers that Merit gave Mr. Moorhead?
So that discrepancy gets into the application of engineering, the application of sciences, which is something engineers have to deal with all the time. So scientifically speaking, the chemical program would be designed at a very specific water rate. And let's say we designed it at 3 barrels of water per day, and we come up with a quantity of chemical that would give us the desired parts per million. Usually as an applications engineer, which is what I am, it's what most operating engineers are, is we over-design in those just a number of things so that we have room for error. And that room for error, we always design in a way that means if we mess up something or something is just not as precise as the data we have is given, we're still going to be safe. So if I was designing a chemical program for a well that made 3 barrels of water per day, I would tell the chemical company it makes more than that or design it for more than that so that they would oversupply chemical to us with a margin of safety. So that if for a day the pump doesn't work or we lose power or a number of reasons, we're going to be covered. And I believe the discrepancy in numbers that you're looking at is an example of that. The difference between engineering and science. Science is very precise, whereas engineering is, broadly speaking, pragmatic.
Were you the ones that provided the numbers to SGB?
No, that was the same engineer I mentioned earlier, Keaton. He's the operations engineer covering this area. He's a Merit employee engineer. He was the one that was working directly with Mr. Moorhead on that.
So is Keaton the main one handling this application at this point?
No, he's not. I just asked him to help me with the chemical recommendation plan when the order from the first hearing came out that we needed to provide a detailed chemical plan to staff for review. So I asked Keaton to help me on that.
I don't know that I have any further questions. Thank you.
All right. Thank you, Mr. Marsh. Let us turn to commissioner questions, and I will begin again with Commissioner Keen. Do you have any questions for this witness?
Yes, thank you, Chair French. Start with the easiest question of all, Mr. Lahetsky. By the way, good morning.
Morning.
Thank you for being here. Are all produced waters from oil and gas wells corrosive?
They all have the potential to corrode. It's like I testified with Mr. Marsh that word is not very definitive. But yes, I think the broad answer is yes.
So, mainly the issue to you as an operator is how do you identify, manage, and mitigate the effects of that corrosion? Isn't that correct?
That is a big portion of our daily jobs as operators, yes.
All right. John, I'm going to ask you if you would pull up the schematic of this well, which is contained within Mr. Lahetsky's pre-filed direct testimony dated 12/28/23 as Exhibit M10. And I believe we have that. If we could, everything's pretty small here, John. I really want to focus on right there. Freeze that right there. Can you see that, Mr. Lahetsky?
I can see the screen, yes. What specifically are you referring to?
I'm getting there. Bear with me.
Okay.
Just want to see make sure that you can see it the way it is right now.
Yes, I can.
Very good. Okay. For the benefit of the commission, what is surface casing?
Surface casing is the first string of casing run when drilling and completing, when constructing a well, maybe is the best word. And the primary purpose of that surface casing is to go, or of all surface casing, excuse me, is to go below the lowest, deepest depth of fresh water, so that in the remaining construction and operation of the well, you have an additional barrier, which the surface casing provides that barrier from the wellbore operations to the lowest known depth of usable fresh water.
Okay, so generally speaking, it's an effort to isolate the fresh water from the rest of the well, basically.
Yes, that is as I understand it, the primary purpose of surface casing. There's a number of secondary purposes, but that's the primary purpose.
So in an effort to accomplish that result, you're running in steel casing. In this case, we can see it's right there at the top on the left-hand side. It was 8 5/8, pretty good sized surface casing. But what's more impressive is the depth. It shows that it was set to a depth of 1,457 feet from the surface. So you have the casing in place, but that's only part of the story, isn't it? Doesn't it have to be cemented into place?
Yes, as KCC requirements during wellbore constructions, we do have to demonstrate that the cement of the surface casing goes to surface before we can continue constructing the wellbore.
And in this case, that required 800 sacks of cement. Am I reading that correctly?
That's how much was pumped. Yes.
Yeah, it may have over displaced more, but in any event, that was probably the measured amount that would more than cover the space between the bore and the outside diameter of the surface casing. Would that be correct?
Yes, 800 sacks is could run the calculations quickly here, but probably significant excess over the annular volume between the hole size drilled and the outside diameter of the surface casing. The goal in that job is to get cement returns to surface, which is a direct indicator that you have cement all the way to the surface.
Right. And the TD of this well, ultimately, that was cased here is in the range of 4,900 to 5,000 feet, is it not?
I believe it's on that diagram at 5,011 feet.
Yeah. So roughly a fourth of that distance is covered by surface casing too, is it not? So you have that many more, you have basically 2 layers of protection on the fresh water.
Yes, correct.
All right. So basically, that's the primary function of surface casing, to be sure, is to protect the fresh water. And the setting of the surface casing, as you indicated, I think occurs. It's basically the first step in the drilling process, is it not?
That's correct.
And that surface casing that's cemented in, it has to be cemented from the shoe, which is the bottom of the surface casing, to the surface, does it not?
That's correct.
And it has to set up before the drilling operations can commence. There's a hiatus, isn't there, between the time the surface casing cement has been process has been concluded before the drilling process to continue drilling to TD can commence. Isn't that correct?
Yes, the cement has to demonstrate a certain amount of compressive strength, which is just, it's drying and getting harder.
The point of all of this for me is not to try everybody's patience, although it may do it, but I'll just have to run that risk. The point of all this to me is, given the construction of the well as it sets today, in your opinion, is the fresh water adequately protected from the from the internal mechanics of the well?
Yes, I believe the fresh water is adequately protected. And I also believe that in the first hearing, all parties did agree to that question.
Okay. Well, thank you very much. John, you may take that down if you would, please. The chemical inhibitors and all that was certainly discussed with Mr. Moorhead. We may have more on that later. I want to really focus with you, if I may, on the mechanical integrity issue. And toward that end, John, if we could bring up again Mr. Sullivan's supplemental testimony of January 18th, 2024. In specific, let's start with page 3. Toward the bottom of the page.
I think I have the bottom of page 3 here.
You are, thank you. If you would, let's go on up just a little bit more and see if we can also pick up the top, down, I'm sorry, pick up the top of page 4. Fine, that's perfect. What I'm focusing on here, Mr. Lahesky, are lines basically 20 through 23 on page 3. I don't know if we'll get to it, but perhaps 1 through 3 on page 24. Let's focus on 20 through 23. And Mr. Sullivan is saying that in anticipation of this hearing, that the staff would not be opposed to requiring the operator to annually conduct a radioactive tracer test to verify the fluids being properly injected below the packer. What's your take on this? Do you have any concerns about this?
So I did testify. I have 2 takes right now. My first take is I should have directed my answer to Mr. Marsh earlier to this statement rather than the one earlier in Mr. Sullivan's testimony, as an example of Mr. Sullivan agreeing that the injection survey radioactive tracer tests can verify that the fluid is properly being injected below the packer and into the permitted zone, using his language. So that's my first take. Should have come here a few minutes ago. Second take, annually is a word or a frequency that I don't think has been discussed at any part of this process until this point in the testimony. It would be a bit excessive in cost to complete that annually. Normally, mechanical integrity tests are required every 5 years. Radioactive tracer surveys are significantly less expensive than a full well intervention. However, they're significantly more expensive than a standard mechanical integrity test. It's just a pressure test. So I'm not sure where the annually came from, is I guess what I'm saying. But my take is generally that Mr. Sullivan agrees that it has a use. And I'm just a little bit confused about why it was proposed annually here.
Okay, if I understand what the operator is proposing to do, it is to, at the outset, run these bond logs to verify cementing of the casing, production casing. And in addition, it is to conduct a mechanical integrity test from the is the top of the Wabaunsee to surface. Is that what it would be?
That's part of that's a two-step mechanical integrity test, and the first step would be from the top of the Wabaunsee to the surface.
And the second would be
below the Topeka perforation and above the producing perforation.
All right, very good. And then, if I understand it, what the company is proposing is, the operator proposing here is that basically, in accordance with KAR 823-407A2, that you utilize an alternative test method to conduct a mechanical integrity test every 5 years. And that method is to utilize a radioactive tracer survey, I guess, together with a temperature survey. Is that correct?
Yes, those the tracers and the temperature are run on the same tool at the same time. There's
Okay.
not a differentiation between the two. And we, as a part of our establishment of mechanical integrity, we do propose to run that test every 5 years.
Okay. That's the radioactive tracer test, is what you're saying.
And temperature survey test. Yeah,
And
it's a
temperature.
long word, so I think a few times in the different testimonies, the radioactive tracer and temperature survey was not shortened, but yes.
Okay.
If I may, describe the reporting requirements that we are proposing for the after. I don't know if that's what you're getting.
Actually, Mr. Lahusky, you're clairvoyant. That's exactly what I'd like to have you do. Describe that and how you foresee that would work in tandem with the 5-year radioactive tracer and temperature survey to provide the commission with some assurance about mechanical integrity, please.
Sure. So the KAR regulations, off the top of my head, I don't know the exact number, but if we would like, we can pull them up and just read them directly as a group. But they specifically reference the reporting requirements that are associated with a dual completed wellbore of this style. And what we're proposing, I sort of think that's a silly word because we're proposing that we follow the regulations exactly as required. I guess the proposal is just that those regulations do adequately suffice as an alternative mechanical integrity test. So what the reporting requirements are twofold. And we have to measure a static fluid level after the initial completion of the dual completion wellbore. And we have to determine that fluid level is below the lowest known depth of fresh water. And then we turn the well on, and then quarterly, the first year after installation, we have to report the producing water to gas ratio. So the numbers are not all the same because this process has now gone almost 2 years long and the well has declined a little bit. But as testified, the Pearson C2 makes in the range of 40 MCF a day and 3 barrels of water a day. And so that is the number that we would be required to report quarterly and then annually for the remaining 4 years until another mechanical integrity test is completed, which that's what we're talking about, the tracer survey. So that water to gas ratio basically establishes a baseline of what is coming out of the Topeka and Wabaunsee perforations. In the event of either a casing leak or a tubing leak or a packer leak, then all parties would expect that ratio of roughly 40 MCF a day and 3 barrels of water a day would dramatically change. And if we had a leak in the injection system, the amount of produced water would be significantly higher than 3 barrels of water a day because the injected fluid would be directly produced into the production, completion, and then up into the tubing. If we had a casing leak, then both of these scenarios were discussed in the first hearing, but in the event that a casing leak is flowing water into the wellbore, then the produced water rate would dramatically increase. In the event that a casing leak was thieving all of the water from the zone, from the productive zone, then we would stop producing water altogether. Both are indications that a change has occurred and would tell us that we have lost mechanical integrity.
That
So
is
we're
very,
proposing,
go ahead, please.
Yeah,
Please.
we're just to summarize, we're proposing to follow the exact reporting requirements that are spelled out in KAR regulations associated with the dual completion. And we believe that those reporting requirements were written for the express intent of establishing mechanical integrity in a completion that you cannot conventionally establish it, which we've already discussed why that's not possible here.
All right, thank you. That was a pretty thorough and I think very holistic response to my question about reporting and monitoring. In fact, it saved me asking you a series of questions. They've saved us all the pain of those questions. So let me kind of recap what I think you just said, which was given what the regulation prescribes in terms of periodic monitoring and record keeping and reporting requirements. Coupled with all of these other procedures that would give evidence of changes in the status of the well and its operations, would together with this radioactive tracer survey every 5 years would provide you with and the commission with adequate assurances about invasion of foreign fluids into the casing.
Yes, or I think as specifically worded that we need to come to agreement on to establish mechanical integrity. We believe that regiment of tests and reporting requirements will establish mechanical integrity in an alternative way to a conventional way.
Yes, that's right. That's right. During his cross-examination, Mr. Marsh was asking you, wasn't the conventional method for a non-dual completed well, I don't think that's exactly how it was phrased, but that's the essence of it, for a mechanical integrity test, to have especially if it's not a slim hole, presuming it's a regular well, that you're going to have basically a tubing and packer in place, the injection tubing set above the casing perforations, with the annular space being filled with a corrosion inhibiting fluid of some sort. And then you would pressure test it from the surface. That basically that's applicable, is it not, to a probably I'll probably butcher the language here, but that's a single purpose completion right there. That would be for injection or disposal, wouldn't it?
Yes. So that is, when calling it more standard, a standard completion is, we have established that dual completed wells are not the norm in the industry. Although we've also established that they do exist and in the state of Kansas for this purpose. Yes, for a standard completion where there's no producing perforations on the backside, then usually mechanical integrity is established via a pressure test.
Whereas in a case of specifically applicable to dual completion wells, KAR 823-407A2 provides for alternative methods in lieu of pressure testing, including radioactive tracer surveys. And I'll yield to your professional expertise here, including the temperature survey as a substitute means of doing that, given the nature of the completion. Isn't that correct?
Yes, the regulations, under the assumption that I'm reading into the regulations, which it doesn't explicitly say this, I think Mr. Marsh asked me about it, is because a conventional pressure test is not possible with a dual completion, Then it provides paragraphs about alternative forms of mechanical integrity test. It doesn't say because a conventional pressure test is not possible, but if you just thinking about the constructions or looking at the wellbore designs, we can all come to the same conclusion that a conventional pressure test is not possible for a dual completion well. So if you use the logic that you have to have a conventional pressure test to have any sort of injected permit approved, you are effectively negating any route towards a dual completed wellbore.
Okay. I think we can probably inferentially conclude that the adoption of KER 82-3-407 wasn't a meaningless act, but it was intended to specifically address the situation of dual completed wells. That's a rhetorical statement on my part. You need not respond. I have one more question for you, Mr. Lahesky, and I'm finished. And John, to do that, I need to have you bring back up what you've taken down on the screen share. To refresh your recollection, I think you've got it. You've got it. That's correct. If you could scan up just a little bit more, please. Okay, make it scan down. Down more. I want to pick up page 4, the top of page 4. Slightly more, slightly more. That's fine. No, oh, you had it. There, that's perfect right there. Again, to refresh our recollection about the source of this, this is from Mr. Sullivan's supplemental testimony, and we're on page 3. Let's look at lines 22 through 23 on page 3, over to lines 1 through 3 on page 24, and I'll read into the record. It says, however, if the commission, and this is Mr. Sullivan speaking, determines that operator's application should be granted, then a condition of the permit should be to require the operator to pressure test the well at least every 5 years. And it goes on and references ordering clause A without going into that reference at this point. My question to you is this, Mr. Lahesky. You've alluded to it previously, but what would you anticipate the expense to the operator would be if you had to actually undertake the pressure test that Mr. Sullivan is suggesting here every 5 years?
So my anticipated cost for the test done every 5 years, the conventional test as proposed by Mr. Sullivan, would be in today's dollars around $25,000 per test. And that is about 3 days worth of rig time, contracted work over rig time, plus some rental equipment, plus replacement of equipment that gets broken while we're moving everything around.
Okay. Very well. Well, I appreciate very much, Ms. Lahesky, your indulgence of my questions. I believe at this time that concludes all of my questions. Thank you, Mr. Chair.
Thank you. Commissioner Keither, any questions for this witness?
No, the last one that Commissioner King just asked was where I was headed, so we've got an answer. Thank you.
Thank you. Well, before we let you go, Mr. Lahesky, I think I have just a couple broad things to ask about and draw on your experience. I think in our prior proceedings, you indicated that you do work in a number of states and jurisdictions. Is that correct?
More accurately, historically, I've worked in other states and jurisdictions. I do currently work in Kansas and Oklahoma.
Okay.
As a reservoir engineer.
Well, I'll just have you answer these questions to the extent you can. At page 4 of your, this would be your direct testimony that was filed in late December. You talk about the tracer and temperature survey, and I think you refer to it as an industry accepted method to trace where the injected fluid is going. And in this situation, we're trying to use it as an alternative to an MIT under our regulation. In your experience, is it accepted? Is it universally accepted in every jurisdiction as an alternative to a conventional MIT? Is it accepted in some states and not others? Could you just expand on that a little bit?
Sure. So think about it a little bit. I would probably broadly answer that universally in all applications, it is not accepted as a radioactive tracer, because that's just a really broad set of criteria. And so I'm sure we could find examples that that's not the case if we thought about it. I do think that it is well accepted that what it is designed to measure, which is where the injected fluid is going, I think it is universally accepted that it does that.
Yeah.
So here, if we could see where the fluid was going, then I do think that, and I'm repeating myself, but it would establish mechanical integrity of the injection tubing and the injection packer that isolate the injection completion from the rest of the wellbore. And so I do believe that, universally speaking, generally, it's a big absolute word, industry professionals would agree that it can accomplish that.
But that would be separate. So, and I understand that is what you testified to, is that it is industry accepted method to follow or trace where injected fluid is going. But it wouldn't be accepted in, is it accepted in any jurisdictions on a blanket basis as an alternative to a conventional MIT?
Yes. So the example that is like most applicable to answer this question, Mr. Sullivan actually did include in his testimony, and that's if you have a wellbore that does not have an annulus at all. So there's no casing, or there's no gap between the production tubing and casing. The most common reason for that is your casing is either really small, like the same metal size that we use as production tubing, or you've cemented your production tubing in place for whatever reason that has occurred. It's basically considered a universal alternative MIT in that situation.
So, but for a design like we're talking about here, would I be correct to say that most jurisdictions either don't allow it or they would allow it on a case-by-case basis, like our regulation appears to treat it?
So they would, presuming for a lot of different jurisdictions, but I do think they would allow it to establish mechanical integrity of the injection tubing and packer. And I would think that, or suppose that, the establishment of mechanical integrity of the casing would have to be accomplished another way.
Well, I'm going to ask you one more. Well, you said establishing mechanical integrity of the casing would have to be established another way. And what, just describe for me what the methods are, lay out bullet points of how we're doing that here.
So bullet points in this application, what we're proposing is that the reporting requirements of the static fluid level and the producing water to gas ratio over time will in of themselves establish mechanical integrity of the casing. That is what we're proposing as part of this application.
And you believe that is more effective and certainly more cost effective from your perspective than...
It's more cost effective, to answer that one quickly. And then the frequency of it is more effective than a conventional pressure test every 5 years, just because it's done on a quarterly basis.
Yeah.
And the reality, the reporting is done quarterly, but Merritt, as the operator, watches this well daily. Previously, we've testified that we well test it every 4 days. And so we would know pretty, I'm assuming it would be pretty obvious if we're producing 3 barrels of water a day for 3 years or 4 years. And then one day we show up and it's making 100 barrels of water a day or more, that we would know that that indicates that we've lost mechanical integrity.
And forgive my my lack of knowledge here, but a condition in an order, I know you've said you catch leaks this way. I
Yes.
know that's in your testimony. Are you under an obligation to report that within any particular time frame to us if you believe you've lost mechanical integrity, or do you just go to work on it in
So
this specific situation?
I believe the answer to your question is in the regulations that have been included in this exhibit. And if I'm to summarize off the top of my head, they say, number one, we have to immediately cease operations. So the injected fluid that we're going to the well, we have to immediately shut off. And then we have 90 days to basically remediate the loss of mechanical integrity and or temporarily abandon the well. So we have to notify staff that we've lost in mechanical integrity, we have to shut the well in, and then we have 90 days to remediate the situation.
Okay.
And it's a few paragraphs down from like where we've been focusing.
Okay.
It is in there.
Very good.
It's
I know
the paragraph there isn't specific to dual completed wells. It's just if any operator in any ejected well loses mechanical integrity, these are the steps you have to.
Okay. We've also talked about a potential additional condition of a cement bond log as a condition. Is that further assurance of well integrity, or how would you view the benefits of that for this commission?
Sure. So in any injection application, one thing that needs to be established is that the injected fluid will only enter the formation that is being permitted. Behind the casing, cement is the only way to direct where fluid goes or doesn't go. And so the cement bond log would be for the purpose of establishing that. And I would like it to be noted that we have submitted the original cement bond log from the original completion of the well. And that shows that the cement top is, I believe, 3754, which is 1,500 feet or so above the Morrow perforations. The cement bond log that we have not submitted because we could not find in the records was the one from 1989 during the recompletion to Topeka, where remedial cement was squeezed at the depth of 3,400 feet. And the bond log, the records state in the completion form, that is also public record, that the top of cement was moved to 700 feet from those remedial cement work. But we have submitted the bond log that shows there's cement across the target injection zone. The cement bond log that we've proposed to run really is a compromise that we've given with staff. I would say, practically speaking, there's no knowing whether there's cement above the producing perforation doesn't really affect the injection portion of this application. But because we didn't have it in our records, we're just, we've acquiesced. If
trying
that's
to,
approval,
yeah, and I'm trying to follow along with the schematic here, but with the bond log we're discussing that we don't have, would that give us more assurance that there is cement fully along the remaining dead zone?
Yeah, so let's pull up the schematic. I can point out that to you.
Mr. Myers, do you have Mr. Lahutsky's testimony?
Yeah, we're looking at for Mr. Lahutsky's
M10.
direct testimony in 10.
Yeah.
Yeah, give me a moment. There you are.
And just scroll down a little bit so we can see.
Yeah, if we can see the whole, the colors on this are bad. There is gray. Oh gosh, you can barely see it. Is it possible if I show the original PDF as opposed to the scanned one? there's a color in there that's just, I can see it, but to point it out to you would be really tough.
Mr. Lewitsky, John Myers here. You're saying you have the original on a computer that you could pull up if you could share your screen. Is that what you're saying?
Yes, I've got Exhibit N10 and I can show
Yeah,
it.
I believe you have the ability to share your screen.
Okay.
I'm going to stop sharing mine. That'll be a
Okay.
start.
Give me a second here. Participants share screen. Here we go. Let's do screen 1. Sure. Okay, you guys should be seeing YouTube. And
Yes,
now
we are.
maximize this. Okay, so this is the original M10. It's just not the scanned version. This color of cement right here, see this little gray highlighting? It just did not show up in that scanned version very well.
Yeah.
And I'm going to be referencing it because it's there to signify the cement. Okay, so in the original completion, up here, what this states that I'm highlighting is that 175 sacks of cement were pumped from the shoe of the production casing, and the top of that cement is 3754. So this drawing is not to scale, it's just a diagram, but 3754 would be somewhere around where my mouse is now. It's above 4650, 4818, but it's below the producing perforations. So at the time of original completion, which I believe was 1985 in this well when it was drilled, a bond log was run that showed the top of cement at 3754. Okay. Now, when Oxy or cities, I can't remember which one was in charge in 1989, when they came by and said, we want to take this well and turn it into a producing well from the Topeka and the Wabunsee, and the depths of those zones are from 2800 to 3258. They said, we want to produce that zone as a gas completion. We don't have cement there. There's not cement. The cement is only to 3754. There's no cement across these producing completions. Very bad practice and probably against the regulations, although I don't know this off the top of my head. You're not going to perforate a zone where you don't have cement because you're just allowing everything behind the casing to come into your wellbore there. So what did they do in 1989? They perfed squeeze holes at 3,400 feet. Oh, well, this is the proposed completion, not the original or not the current design. I think that's like exhibit M1, but maybe I can pull that up just a better current wellbore schematic. You guys see this one? This is exhibit M1.
Yes.
Okay, so this is currently what the wellbore looks like. They perforated at 3,400 feet, which was above 3754. Roughly, what is that, 350 feet above 3754. The reason why they perforated at 3,400 feet, and then they pumped an additional 450 sacks of cement. The purpose of that work was to move the cement from 3,400 feet up above the future producing completion zones, so that they could perforate those and turn this into a producing well in those zones. The rig reports from that time state that 450 sacks was completed, and that that a CBL was run on April 7th, 1989, and that CBL showed the top of cement is 700 feet. So that is the CBL that we cannot find. But it is not referencing any cement that's associated with the injection zone, which is the distinction I'm trying to make now. It's only referencing cement that is associated with the producing completion, which is a part of this well because it's dual completion. But as Mr. Marsh was actually hinting at earlier in his cross-examination with me, not actually the purview of the application, just because the application is an injection application.
Gotcha.
Now, this top of cement at 700 feet does exist also in the public record. It's not just like an internal merit report. The ACO1 form that was submitted in 1989, that's required whenever you recomplete a well to a new zone, stated that the top of cement, stated the remedial cement work, that 450 sacks was pumped from the depth of 3,400 feet, and that the new top of cement is 700 feet, We just don't have the bond log.
Okay.
And we have submitted that completion form as part of this hearing as well.
Gotcha. Okay, I think we can take these down unless Mr. Lehetsky, you had anything else you wanted to reference.
I don't.
Chair French, if I might, I have a follow-up question.
Sure.
You prompted
Sure.
it. Going back, Mr. Lehetsky, to the last line of questioning that you and I engaged in a colloquy about, having to do with Mr. Sullivan's proposal that there be a pressure test of the well every 5 years. If I'm understanding your testimony, if the commission actually adopted that as a requirement for the approval of this application, I'm going to choose my own choice of words here. That would be a poison pill, in the sense that the company would basically decide not to complete this as a dual completion well. Is that correct?
We would have to think about it, but most likely the answer is yes. We'd have to ask ourselves if that cost is worth it. So, but it is a significant increased cost from a normal injection well.
Yeah, and that would be because of the increased cost, and if I'm understanding your testimony, the risk. Every time you place and remove a packer, there's a risk, is there not?
There's anytime you intervene in a well, rig intervention is the word I've been using for this hearing. There's risk that something falls, gets stuck, breaks, etc. So that's the risk that I'm referring to there.
Yeah.
Adding
Okay.
risk to the conditions of approval that, in my opinion, are unnecessary.
Yeah, when I think you're saying it's unnecessary because you think the alternative methods for basically arriving at the same point should be satisfactory.
Yes.
Thank you very much. When Mr. Alewski's testimony is concluded, Mr. Chair, I have a proposal to offer to you whenever we
Okay,
reach.
sure. I do have at least one more little line of questioning here, and then we'll allow redirect. Mr. Lehetsky, the last thing I wanted to ask you about, are you familiar with the petition for reconsideration that staff filed in this docket? I believe it was back in August. Are you generally familiar with that document?
I'm generally familiar. I did write a response to that petition.
Do you recall staff bringing up, and I don't know that we need to bring up the petition for reconsideration. I have it in front of me. Toward the end of that petition, they brought up a peer review program that they did through the Groundwater Protection Council, and that had a series of recommendations. Do you recall that part of their petition for reconsideration?
I do recall that study was mentioned. I don't know if study is the right word, recommendation. I do recall that it was mentioned. I don't have direct familiarity with whatever that document or recommendation is.
Do you recall that one of the recommendations was that our conservation division consider phasing out any permitting of dual completion wells that are used for both production and injection, because as the recommendation went, tests for mechanical integrity of these wells has not been shown to be an accurate means of evaluating well integrity?
I do recall the petition, and I think that actually gets to the heart of probably what this hearing is.
Absolutely. And I guess I'm again just wanting to draw on your experience perhaps in other jurisdictions. I mean, I was curious because that was a peer review program, drawing on other jurisdictions' experience. Do you operate in any other jurisdictions that have taken that view and have phased out any application of these types of dual completions?
No, I am not. I don't operate in any jurisdictions that I'm going to just say dual completions are off the table for whatever reasons are mentioned in that study.
Are you aware of anything specific about Kansas's geology or other conditions that would make that recommendation right for other states, but wrong for Kansas? Any light you could shed on that? And I'll probably ask staff about this as well, but that seemed like a very substantial thing. I was surprised it wasn't raised in the follow-on testimony. But I guess I'm trying to understand how I should look at that report. Is there something about Kansas that makes that recommendation inapplicable?
I do not believe that there is anything about Kansas, or specifically the geology within the Hugoton Embayment, which is the basin that we're talking about right now, which spans the southwest corner of Kansas and some of Colorado and some of Oklahoma, that makes that report applicable in that basin versus another basin. I don't think there's any specific about the basin that would surmise the report.
Well, I know it's not your report, it's not your recommendation. I just I thought I would ask if you had any experience in other jurisdictions with that practice. So with that, I believe I've come to the end of my questions. Mr. Schlatter, do you have any redirect?
Just brief record cleanup type items, if I may. Thank you. I guess to dovetail off Mr. French's point, are you aware of any jurisdictions that have phased out dual completions, Mr. Lutsky?
No. To repeat myself, dual completions are generally considered an on the table operational route that we have to operate within.
Are you aware of any jurisdictions that require a pressure test in the production interval and a due completion?
No, it's mechanical integrity is by nature of the dual completion required to be established in some other method, some other way.
You mentioned we talked a little bit about cement behind the casing. Can you just explain why that's one of the reasons why that cement is there?
There's a couple of reasons why the cement is there. I want to say the primary reason. So a long time ago, when these wells were completed, let's say the 20s, oil and gas wells were, typically completed back in the 20s. Small amounts of cement were pumped to basically prevent the casing from moving over time. So it was just to hold the casing in place. Practices have evolved significantly since the 20s, and now the cement is used for basically a bunch of reasons that all point towards adding integrity to the wellbore. So I would believe it to be generally true. The more cemented pipe you have, the larger percentage of your casing that is cemented, the more integrity you're going to have in that well. Your casing is going to last longer. The cross flow between zones behind the pipe is going to happen less and not at all where there's cement. And so I would say that's the primary reason for cement being pumped.
The one reason is to prevent fluids from touching the pipe on the outside diameter, which could cause corrosion. And the other being, if there were corrosion inside of the pipe, the cement would be a redundancy to that.
That is a good example. And I actually come to mind some time in North Dakota. So at the time we were drilling Bakken wells, which were in depths of like 7,000 to 11,000 feet vertically. And there was a zone called the Dakota Sandstone, which previous decades of development prior to the Bakken blowing up was primarily used as a saltwater disposal zone. The best equivalent we have here is the Lansing. So we talked about the Lansing being used as a saltwater disposal zone for in a lot of places. It's just used in a lot of places in the Hugoton Embayment as a saltwater disposal zone. There are some jurisdictions that require the construction of wellbores now to have cement, North Dakota specifically, above that Dakota sandstone. And the purpose of that is because they just know there's a ton of disposed fluids in that sandstone and that you need to protect your well from it. And if you don't protect your well from it, eventually you're going to cause problems. So that would be an example of an additional requirement that another jurisdiction has that Kansas doesn't really, the current Kansas regulations don't opine on.
With the, you mentioned a bond log conducted when the well was originally completed showed that cement had reached a surface, or had gone from bottom to a depth of, I believe, 3,700 feet. Is that right?
The original completion, the first cement job, that's what the bond log showed, and we have also submitted that bond.
And as redesigned, the so-called dead zone of the well would be beneath that. I mean, the entire dead zone will have not just pipe behind it, but also cement. Is that correct?
Yes, I'm actually surprised we haven't really got to the part of the redesign yet. My testimony here. So the primary change of the wellbore design between the last hearing and now was the addition of the siphon string, which forces fluid to move down to the bottom of the siphon string and then up the production tubing before it's produced, rather than just entering the production tubing at the depth that the pump is set. And so forcing that fluid down and around, we're saying remediates the risk of a dead zone occurring, because it turns that zone into an active zone from a dead zone. So now you've got fluid day in and day out replacing it at a rate of 3 barrels a day that we've established the well is making on average. The annular volume between the production perforations and the bottom of the intake will basically be refreshed or replaced with new produced water about every 3 days. And so it won't be a dead zone anymore. It'll be a zone with moving water. Live zone.
Where that zone is, whatever it is now, the 160 feet that I believe was referenced earlier, there is a redundancy there. If there were something to happen with the cement casing or the casing, there's cement behind that casing.
That's correct. So a big portion of the first hearing was that some of the dead zone would, the casing would be, the fluid would be dead, in air quotes, not moving by design, across the uncemented portion of production casing, which is the depth between 3754 and 3400, where the second cement stage was pumped. So that depth, nobody expects there to be production cement across that production casing. So the first hearing was focused on the dead zone was across that zone, because that casing was less protected than the casing that has cement around it, that added additional risk. So the new wellbore design moves the dead zone down and reduces it in quantity by, I think you said 90%, down to a depth of 168 feet above the injection packer and below the siphon string. And that 168 feet is entirely across casing that has cement behind it, that has a bond log that shows that we have submitted as part of this application.
Okay, last question. Commissioner Keither asked a question about the cost to do the full-blown pressure test on this producing interval. I believe you said it was around $25,000. Off the top of your head, what does it cost to do a casing pressure test on a standard single completion injection well?
It's of minimal value, not measurable value. You've got fluid in the well. All you have to do is connect a pump with a gauge on it, and we have enough injectors as the company that we own all that equipment already, and pressure it up and measure it, record it for 30 minutes. The state witnesses were required to report to the state when we're going to do that test, and then at least 25% of the tests that we do are required to be, a state witness is required to be present. But we own that equipment, and we own, the operators work for us that would be doing that test. So it's really no cost at all. So the difference is from 0 to 25,000.
That's all the questions I have.
All right. Well, I don't think, unless there is recross, which I don't think we got into too much new, let's just go ahead and move forward. Mr. Luhutsky, you may step down. Commissioner Keen, did you have something you wanted to address at this point?
Yes, thank you, Chair French. Before we move to the staff witnesses, I would request respectfully that we recall Mr. Moorhead. I would like to have him testify about some of the matters that were the subject of Mr. Marsh's cross-examination of Mr. Luhutsky, where Mr. Luhutsky was not present when there was conversations with staff.
Okay, well, I was going to ask if Mr. Moorhead was available, but I I see him in front of me on my screen. Since he is here, that's certainly fine with me. Mr. Schlatter, would you like to recall Mr. Moorhead?
Yes, no problem. Applicant calls Mr. Micah Moorhead to the stand.
And Mr. Moorhead, since I did have you step down, I want to put you back under oath. So if you'd please raise your right hand for me. Do you swear or affirm that the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. I believe this is for the sole purpose of a couple questions for Commissioner Keen, so I am going to hand you to Commissioner Keen at this point.
Thank you, Chair French. Good afternoon now, Mr. Moorhead. John, if you could assist us here. I'm looking at Mr. Luhutsky's pre-filed direct testimony, page 5. In particular, John, what we're focusing on here are lines 10 through 27. That captures it. Mr. Moorhead, can you see the shared screen?
Yes, sir.
Segment here. Very good. Were you present during the cross-examination of Mr. Luhutsky by Mr. Marsh?
Yes, I was today.
Do you recall that during that cross-examination, Mr. Marsh directly referenced these lines that we're focusing on right now on page 5 of Mr. Luhutsky's direct testimony? And Mr. Luhutsky indicated that while there was this meeting that occurred with Merritt, evidently yourself, and Mr. Jellick, that he wasn't personally present, but that you were. Do you recall that testimony?
I do recall that testimony, yes.
Is that correct? If you had a chance to read this, would you like a moment to read lines 10 through 27?
That would be perfect. I haven't actually seen this particular testimony.
Please take a moment and do that.
Okay. So, the way that the order of events that happened, as I recall them, Keaton, who I more directly reach out to because we interface a lot with like the operations engineers, reached out to me that Ken Jellick might be reaching out to me. I believe I called him, but I did not speak with him. When it comes to regulation, because these are Merritt wells, that is something we would typically defer to Merritt of, hey, we will provide whatever the Corporation Commission deems necessary, whatever we need to get into regulations, but we typically do not ascribe ourselves to say, yes, this will meet regulation. We say, we obviously work with our operators to give them things that are not going to fall short. But when it comes to those specific things, that's not something that we usually ascribe to. I never spoke with Ken Jellick directly. However, because of that, I moved it to my manager. I believe he spoke with Keaton, Ken, and himself. His name is Ryan. And then it came back to me to say, working with Keaton, the engineer for Merit, we need this chemical program designed. So it wasn't, I was not personally on the call, no, but it was work that got placed to me, and the wellbore details and various details were sent to me so that I could put that together.
Have you ever had direct contact with Mr. Jellick?
I don't recall, genuinely. I remember reaching out to him. I remember Keaton saying that he was going to reach out to me, but I don't recall exactly if I ever spoke with him.
Okay, very good. I have no further questions. Thank you, Mr. Chair. Thank you, Mr. Moorhead, as well.
No problem. Thank you, sir.
All right, thank you. I assume no redirect is necessary at this point, Mr. Schlatter.
Commission, Chair French, if I may.
Sure.
Mr. Moorhead, on page 4, lines 2 and 3 of Mr. Lahutsky's testimony, he states that staff made no effort to discuss and understand the chemical program designed by Merit's chemical contractor. Did I read that correctly?
Yes, sir, you did.
Would that be accurate if SGB Solutions coordinated with Ken Jellick regarding the chemical program?
I wasn't a part of that meeting, so I wouldn't know.
But based on what your manager told you, it sounds like staff did.
At,
Collaborate.
at least in that effort. From that testimony that I just read, it was, and from the testimony that I heard, it seemed like it was Ken's idea to lower the, put a sump on the pump. So there was some collaboration there, but I think the dialogue was in some of the future endeavors was lacking.
Okay, thank you. No further questions.
All right. And Mr. Slatter, no redirect, correct? Thank you. All right, Mr. Moorhead, you may step down again. All right, we are at, this seems like a really good spot for everybody to get a short lunch break. We're a little before 1 o'clock. We've still got all 3 of staff's witnesses left to go. Are there any objections to taking a short lunch break since we're already almost to 1 o'clock? Something in the range of 38 minutes to bring us back here at 1:30. Is that acceptable to everyone? All right, I'm seeing nodding heads. Nobody's violently waving me off. All right, we are now off the record and in recess to return at 1:30. All right. We are back on the record for the hearing in this docket. We have completed operators' witnesses. At this time, I believe we are ready for staff's witnesses. Mr. Marsh, you may call your first witness.
Thank you, Chair French. Commission staff calls Kenny Sullivan to the stand.
Thank you. Good afternoon, Mr. Sullivan. If you would please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth, the whole truth, and nothing but the truth?
Yeah.
Could you say that one more time? I don't think your microphone is quite picking you up. I heard a slight sound the first time, and then I heard no sound the second time.
Okay, bear with me. I'll try and get it fixed.
We got you. Kenny, we did hear you that last time.
Okay, did that sound better?
You sound great. Let me try to swear you one more time. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, very good. I think we've got you. Let me hand you back to Mr. Marsh.
Thank you, Chair French. Can you please state your name for the record?
My name is Kenneth Michael Sullivan, but I go by Kenny.
And Kenny, by whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission as a professional geologist supervisor for the District 1 office.
And Kenny, what is your work address?
210 East Frontview, Suite A, Dodge City, Kansas, 67951.
Are you the same Kenny Sullivan who caused to be pre-filed in this docket supplemental testimony consisting of 6 pages on January 18th, 2024?
Yes.
Was this testimony created by you or at your direction?
Yes.
Now that you are under oath, do you have any corrections to make to your testimony?
Yeah, I feel I do.
What is the correction?
Okay, so on page 5, line 21, I misinterpreted my math or didn't give an accurate description of the annular space in the wellbore. Basically, in my drawing and head that day, I basically made a cross-section cutout, if you will, of the wellbore with the 2 tubing strings in it and said that leaves an annular space of 0.887 inches. You know, that math is that accurate, but that is not an accurate reflection of the annular space in the casing. It is probably closer to 13, or it is actually 13.048 cubic inches of annular space in that wellbore, and that is in cubic inches. So I wanted to make that correction.
Do you have any other corrections?
I do not.
Now that you are under oath, do you have any, sorry, gotta go to the next question. If I asked you the same questions today that are contained in your testimony, would your answers be the same?
Yes.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge? At this time, staff moves for the admission of Mr. Kenny Sullivan's pre-filed supplemental testimony from January 18th, 2024 into the formal record.
Is there any objection? Mr. Schlatter, I think you said something, but it didn't come across on my end. Okay. I hear no objection. All right. Then the reference testimony will be admitted into the record.
Thank you, Chair French. At this time, staff tenders the witness for cross-examination.
All right. Mr. Schlatter, do you have any cross-examination for this witness? I am still not picking up your audio. I don't know if that's just my issue, but I'm not catching your audio.
I'm not hearing him either.
Okay.
Neither.
Just try talking for a minute and see if your computer picks you up.
I guess no one's ever asked me to try talking for a minute, so that's a
We've got you now. I think you're a little faint, but I think we've got you.
Okay, it wasn't an issue earlier, was it? Okay. Well, I just muted and unmuted, and I have no idea why that would solve the problem. But apparently it did. So yeah, the issue, I've got a laptop docking station, so if the laptop's not on the desk, it doesn't pick me up. But if may I proceed?
Yes, please proceed.
Okay, thank you. Good afternoon, Kenny.
Good afternoon.
Glad you brought that issue up with the diameter of the tubing versus the interior diameter of the casing. That was something I caught when I was reading your testimony. You said cubic inches. Do you mean square inches?
Correct. Yeah, square inches. I'm sorry. Yes, inches squared.
Look, 13 cubic inches wouldn't be much room for anything.
Again, thanks for the correction.
Yeah, I don't think that would fit in my shoe. So, and I had done a real crude, I don't know if you want to call it experiment, but I took this quarter and this roll of tape and kind of used them to make a scale drawing of what I think this looks like from above. We have a bunch of pictures of the wellbore from the side, but nothing from the top. And I think you were trying to articulate what it looks like from the top. This isn't to scale, but that is more or less what it looks like.
Yeah, and so if you can imagine, what I did was drew a straight line through all three circles and
Right.
went it that way. And I didn't square the circle. So
Right. So we have 0.887 of space between the outs, the very extreme diameter of these. But obviously we've got more than that here and here.
correct.
Okay. So I just wanted to demonstrate that. And your concern in raising that issue was that there wasn't adequate room for chemical or clots or the quarterly flush to go down.
What I was trying to depict was that there will be, increased friction from the extra tubulars in the well, that would likely increase the gas velocity coming up the hole. Yeah, and then Mr. Moorhead did give me a diameter of the pellets in 12 millimeters, I think that was the biggest, 10 to 12 millimeters. And no, yes, it's still a tight squeeze no matter what. I mean, it's not like the wellbore diagram depicts that it's perfectly straight 13 square inch hole all the way down. But yeah, I was just trying to visualize the tight annular space in the wellbore.
13 square inches we're talking about is everything that's not inside these two circles, right?
Correct.
Okay. And do you have any concern that a 10 or 12 millimeter pellet would not be able to fall down that 13 square inch area?
Well, obviously, if it looked like that, there shouldn't be an issue. I would suspect, though, that the two tubing strings would, barber pole around each other as they ran in and wrap around each other, I guess. Maybe lean up against casing at some point and all that fun stuff. So I believe I said it would impair or impede or inhibit, how that falls. I didn't say it would not fall. The pellets would not fall, but
Flushes that might push those pellets further down as well.
I'm sorry, I didn't quite catch all that.
No, with those monthly flushes of the score 450, that would help push those down further as well. Is that right?
The half a gallon of score 450, it's my understanding in reading the testimonies and exhibits that'll just be, deposited a half a gallon at a time. And
Plus, with the production fluid to help push it down.
the production fluid from surface.
Right. Mr. Moorhead testified how that liquid chemical was applied, and it included a dose of produced fluid to help wash it all the way to the bottom.
I think that was with the quarterly batch treatments that is followed by flush water.
Yeah, I believe it was both, but I think we're splitting hairs here. To get to the point, do you have any reason to doubt that the monitoring that SGB Solutions intends to employ would help determine whether or not these pellets are reaching the bottom, or that the score 450 is applying itself to the metal inside the casing?
No.
Kind of getting back to the first hearing we had on this, you testified that one of your biggest concerns was the uncemmented casing directly behind the dead zone, specifically from the depths 3,400 feet to 3,754 feet. Does the proposed redesign that Merritt put together satisfy your concern in that regard?
Yeah, with the uncemented zone, yeah.
Okay. There's been reference to a gentleman named Ken Jellick. Can you tell me who that is and what he does for the commission?
He is an ECRS and he was stationed out of Garden City. He's in charge of 6 counties. I believe he's a graduate of Kansas State University with a geology degree from a while back. He worked after school, he worked with Dowell as an engineer for several years. Eventually retiring as a production superintendent with Helmerich and Payne around the year 2000, I believe, and came to work for the commission as what's now called an ECRS in 2005. You cut out.
Is Mr. Jellick somebody that, as an ECRS, that reports to you?
Yes.
Is it your understanding that he had some part in this wellbore redesign?
Yes.
That he maybe even came up with the idea?
Yeah, it sounds like it.
Okay. And then did you have any discussions with him about the wellbore redesign, or did it just stay at that?
No, he discussed it with me.
Okay. As far as the redesign, I mean, it satisfies your concerns about the uncemented dead zone. Any other issues that it satisfies with regard to the dead zone?
Well, I believe when you quoted my testimony, you said one of my biggest concerns was the dead zone, not my only concern. And as such, I mean, like with every injection and disposal well that I testified to when we talk about MITs, is that we have to ensure integrity of the packer, the tubing, the casing, and the wellhead. So yeah, maintaining packer integrity, and tubing integrity, and casing integrity are equal importance. And
do you believe on the topic of mechanical integrity testing, the radioactive tracer testing is adequate to demonstrate the integrity of at least the injection tubing and the packer, and the functionality of injecting the fluids into the zone of object?
Yeah, it'll trace down with it'll show the, assuming there's no catastrophic failure in the tubing or packer, it'll demonstrate the water is in fact going out the bottom of the packer.
And if there were a catastrophic failure, it would show that because it would trace those fluids either where the hole in the tubing is or where the packer is failing, correct?
Yeah, I mean, it will, I don't know. It depends on how the backside, what the exact issue is, but yeah, I mean, it'll essentially, you're going down and waiting for it to pass by again. And if it doesn't come, you try and trace it back up. And I mean, I don't know that it would necessarily pinpoint, but yeah, it would show it.
It would show it somewhere other than where it's supposed to be.
Right.
So really the only issue, correct me if I'm not understanding this right, but your biggest or only issue or remaining issue with mechanical integrity is the ability to test the casing from the top of the packer to surface. Is that a fair statement?
Yeah, that's an issue that, the radioactive tracer survey doesn't address.
It wouldn't identify a casing leak there.
Correct.
Okay. And beyond that, we're okay with the mechanical integrity being proposed, at least as far as the radioactive tracer shows.
Can you clarify that a little more?
Well, I asked you if the only remaining concern you had was the ability to test the casing from the top of the packer to surface, and you didn't really say yes or no. Is that the only remaining concern you have in the way of mechanical integrity?
As far as being able to determine mechanical integrity?
Demonstrate it, yes.
Okay. Yes.
Okay. What's wrong with the periodic monitoring and reporting that the commission's regulations prescribe? Why isn't that adequate?
I think it's going to be difficult to determine, in my opinion, the fluid level in the wellbore with all the extra equipment in the wellbore and the decreased annular space. It's also going to be, there is some confusion by operator regarding how much the well produces water-wise and gas-wise. So, you want to say it's minuscule, but you go from 3 barrels to 7 barrels. That's over twice as much water production you're now making. So, if that were to happen, do we go, well, that's just a common thing. If it goes from 47 MCF to 19 MCF, is there an issue we need to, get into the wellbore and check on, or is that okay? Is there there's no specific guidelines on, how to effectively monitor that. Yeah.
If we do the test prescribed by the regulations, first test establishes a baseline, correct?
The first oil and gas water ratio.
The fluid level test and the gas to oil water, or gas to water ratio test.
After the well has been recompleted for dual injection, that would be our baseline.
I'm asking you.
Yeah, it would make sense to me that would be.
And so then a subsequent deviation from baseline, particularly if it's identifying increased fluid or a significantly decreased gas to water ratio, the point of the test is to demonstrate that that's showing that there may be mechanical issues with the casing.
Yeah, I think the issue I have is, I think it's been well agreed upon by all parties that there's going to be cross flow of the well. And, I think there is a disagreement in what effect that will have on the Topeka. But I think we could all agree on that if that water is entered and we're pumping it out, we're going to be pumping it out at a higher rate than 3 barrels per day or 7 barrels per day. That would be my assumption. The gas could, be 0. It could be 15 at that initial gas to oil water or gas to water ratio. And so is that the initial we want to set? So if
Response to that would be, if you recall, Merritt's already agreed to do a casing pressure test before the well is recompleted. So we will know at that time there is casing integrity, will we not?
yes, at that point, yes, but
And if the water level is decreasing as it's being pumped off, wouldn't that be an indication of continued casing integrity?
it depends on what time frame you're wanting to prescribe this in. Are you wanting to say a day? Most likely. We do a standard MIT test where the rubbers are leaking on the tubing head, and it's likely the culprit of why that MIT is failing. but we don't know what's going on down the hole. I mean, there's only one way to determine that. So, I mean, you know, in 6 months down the road, if it's still making 100 barrels of water a day, you know, we don't know if that's or a year from now. I mean, whatever time frame you want to set. So
I was asking if the gas to water ratio is decreasing, the fluid level is decreasing. That's a pretty good indication there's no casing leak, right?
one more time, please.
If these fluid levels are going down, or the ratio of gas to water, water to gas is going down, that's not going to trigger you to think that there's a casing leak, right? In fact, it probably demonstrates the opposite.
I believe Mr. Lahutsky testified that, I mean, losing water production could be indicative of a casing leak.
I'm asking you if the water to gas ratio is falling, or if the fluid levels are falling, that's a pretty good indication that we don't have a casing leak, correct?
The water to gas ratio is falling as far as
With less water, gas.
is falling.
Would you want to just do this one at a time? If the fluid level is going down, to you, is that an indication of a casing leak?
It can be.
And it
I would-
produces well.
In the interest of time, you know, as an example, over the course of 3 months, if it's effectively going down, once the dually completion, I would not be suspecting of a casing leak.
And we have records showing what the well is currently producing that could be furnished to establish this baseline, you know, before the intervention, after the intervention. So we have good data that will show if there's any significant.
Objection, counsel's testifying.
It's a. I don't know if
As long as Mr. Schlatter's getting to a question at the end, I'll let him continue.
state the question. So Mr. Lahutsky testified that they monitor daily gas production, and every 4 days the water produced from this particular gas zone. So we have records, or Merit has records that will establish what this baseline is before the well intervention, that staff and Merit could get together and figure out what that baseline is pre-workover, correct?
Yes.
And if there is some cross flow, that will be reflected after the intervention or recompletion. And if the subsequent testing reveals that those fluid levels are coming down, then we know that there's no casing leak, correct?
I believe what you're asking me is if after a period of time, if we get to baseline and maintain baseline, yes, that should, that would help indicate that.
And then if those fluid levels drastically increase, that's a likely indicator that there's an issue with either the casing or the tubing, but something to investigate.
Yeah.
And at that point, what Mr. Lahutsky's referred to as a well intervention may be appropriate. Correct.
I'm sorry, I didn't, I thought that was a statement. Yes, correct.
Okay. Let's touch on this issue of cross flow. In the first hearing and this hearing, you testified there was a strong possibility of cross flow brine from the Morrow in the Topeka and the Waubonsie during well completion. And it's your belief that that could cause waste in the shallow gas zone?
Yeah, waste and or correlated brights if it has an irreparable damage to the formation.
If this well had to be pulled every 5 years to do this casing pressure test, wouldn't that risk be manifested over and over again on this 5-year period?
Well, if the risk is there, it is always there, and I don't know how we determine when it's acceptable and when it's not.
I would think deliberately causing that risk to manifest itself would be unacceptable. Would you agree with that?
By drilling the plugs out and letting the
But pull-
formations communicate. Well, you're gonna do it when you, or they are going to do it when they drill out the retainer and bridge plug. I mean, it's that fluid's immediately coming up the hole and invading. I mean, there's gonna be a massive influx of Morrow water or formation water from the Morrow zone.
Right, and that's once. And what you want to do is do that again every 5 years. Am I understanding that correctly?
Well, I believe if it's an acceptable risk, then it's, I mean, to ensure the well has mechanical integrity, it should be, I guess it's an acceptable risk at any time. I'm trying to say that it's not an acceptable risk.
It's an avoidable risk the second, the third, the fourth, the fifth time, right?
Well, I mean, you're talking every 5 years. I mean, that's not out of the realm. It says that in regulation that all mechanical integrity tests should be conducted at least every 5 years.
Why don't we pull up these regulations? Give me a second here. I'll get right to it. I was just looking them over.
There was a dual completed well by a different operator in Seward County that did this annually. This rig intervention pressure test that you're describing, with no issues on handling the equipment annually. So I'm not requesting that, but I'm not unprecedented.
And if I could, I'm just going to interject real quickly here. I'm not going to disallow cross-examination on our regulations. They are something our staff works with, every day. So it's fair game to ask them questions. I would caution not to sort of belabor arguments about what the regulations do or do not say. The commission has counsel, and we can dive into those regulations. So I don't mind some cross-examination, but let's not spend an hour going over the commission's regulations, if that makes sense.
Just want to highlight something. I wanted to do this with Nick, but I forgot. So this is 823407.
Mr. Platter.
Yes, I can here. Okay. And it says an injection well shall be considered to have mechanical tech.
Mr. Schlatter, we're just seeing your desktop background at this point.
Is that better?
There you go.
Okay. So I'm just starting here. It says mechanical integrity shall be established on each well by one of the following. The first one is the pressure test that we seem fixated on. The second one is alternative test methods, which include radioactive tracer tests and temperature surveys. That's one of the methods Merritt's proposing, correct?
Correct.
Next one is monitoring, which is the fluid level and the gas to water ratio. That's another method, correct?
Correct.
And then a third method is, and Merritt's also proposing to do that, right?
Number four?
Well, number three, we'll get, and they're number four, but number three. So number four is duly completed wells, which happens to be the type of well we're talking about today. I think this is really where that monitoring is. The fluid level, the gas to water ratio, oil to water, which really isn't applicable here. And Merritt's also proposing to do that. Correct?
Correct.
So three of the four, in which only one is required, Merritt's proposing to do, the only one is not the pressure test. Correct?
Correct.
Okay. Now I'm going to stop sharing my screen. In a regular producing well, how is a casing leak typically identified?
The operator usually sees an influx in fluid or a loss of fluid, depending on the nature of the casing leak.
And isn't that what this periodic monitoring is intended to accomplish?
I mean, yes, but I mean, drawing a comparison to a producing well and an injection well is not a fair comparison.
I mean, we're really talking about the producing interval of the duly completed well, aren't we?
Yes.
So I think it is a fair analog. Don't you think this periodic monitoring would actually identify these casing leaks much sooner than these 5-year pressure tests?
They can. I mean, once again, it just goes back to the nature of the casing leak and
Kind of turning to the chemical program.
Yep.
Do you have any experience prescribing chemical programs for wells?
I do not.
You have a background in chemistry?
All through my coursework and for my geology degree, but no license or certificate or degree, no.
Is it your belief that the water from the Topeka is so corrosive that it cannot be treated with chemicals?
No.
What chemical program would you prescribe then for this well, other than what SGB Solutions is prescribing?
I have never questioned the efficacy of the actual chemicals if applied to the produced water. It's the mechanism of getting them into the water that I would like clarification on. I think we talked earlier about like the specific gravity of the Topeka water and the specific gravity of the pellets, and how they, that would flow. So all I've looked for is a mechanism of how we can effectively treat that water. Not that it can be cured into fresh water. I mean, I think Commissioner Keene would appreciate I made a silly Kool-Aid reference at the last hearing. I mean, that's always been where I've stood, is I'm just trying to understand and question how this can effectively get to the dead zone and treat the water. Not that that specific chemical wouldn't do it.
Agree that the 4-pronged approach will demonstrate.
I can't hear you.
Please restate it. For some reason, I think it's a Zoom issue, Mr. Slider, but it's just not picking you up the first couple seconds you talk.
Do you agree that the 4-pronged SGB Solutions intends to employ will validate that those chemicals are reaching the bottom?
The 4-prong, I believe you asked me if the 4-prong testing would be effective.
Monitoring.
The 4-prong monitoring, where they use their coupons and that.
Water samples, yeah. They'll show in there.
I'm sorry, I can't hear you.
That the monitoring will demonstrate that those chemicals are indeed reaching the bottom.
Yeah, according to their testimony, yes.
And
To clear that up, I'm sorry.
I mean, does that satisfy your concern?
That it will reach, that the pellets will reach the bottom.
Or that they have indeed reached the bottom?
Yeah, you could get to that point where you could, I mean, I still, there's still gonna be 168 foot of dead fluid, stagnant fluid on top of the packer that I'm still unsure of how you would collect a sample from there to know that it is working. I'm not saying it can't work. I mean, I don't want to make that argument. I'm not saying that. I'm just wanting to understand how it will.
I think that's all the questions I have for Mr. Sullivan.
All right. We're going to move to commissioner questions, and I will begin again with Commissioner Keen.
Good afternoon, Kenny. How many dual completed wells presently exist in District 1?
I want to say around 6 or 7. They are all disposal wells. Most commonly, it's like a Chase producer or Chase producer Council Grove disposal that is just disposing on a vacuum of the fluids that the zone makes.
And how is the well construction on those wells different from the one that's proposed here?
They're only separated by less than 100 feet.
Okay, well, this is not much more than that, is it? The way the schematic's been redesigned, isn't that correct?
No, there's still 1,500 feet between the two zones. The 168 feet is probably even greater than the common things. I think also the difference would be is those wells operate under vacuum, where this well would operate under very high pressure. The formation is charged up to very high pressures for the enhanced oil recovery. So, there's not a lot of chance for cross flow like there is. And there is a lot of reservoir compatibility between the Chase and Council Grove, and that's why you see them commingled so often.
With the packer in place for the injection tubing, there's no cross flow, right?
Not when it's in place, unless it fails.
Okay. And the distance between the bottom of the perforated sub, which supposedly Ken Jellick suggested, and the top of the packer is less than 200 feet.
That's correct.
So I don't see where you're getting the 1,500 feet differential that would be relevant for the purposes of making the case you're making. I'm not following you.
Okay, I mean, even the 168 feet is greater than what we're seeing, but
it wasn't that much greater. From what I thought you said it was like 100 feet or something. We're kind of splitting hairs here. I don't really want to do that because I want to kind of cut to the chase on the big issues. Pardon me, I talked over you. Please, Kenny.
No, I'm okay with where we stand. Yeah.
I guess if we can handle the, I think for purposes of our colloquy here, let's take care of the dead zone and the chemical treating issue first. And so I guess my first question was, did you find Mr. Moorhead's testimony to be credible?
His today or his pre-filed?
Yes, today.
Yeah, I have. I mean, yeah.
Well, I guess what I'm asking then is, having heard this testimony, have you changed your mind regarding the efficacy of the proposed chemical treating program the company is proposing for this well?
I guess there was a couple things that did stand out and just makes me question the ability. And so one of the things is he says they will dump the pellets in monthly, and he will not shut in production. He then later on testified that the pump would suck the pellets up and bring them back to surface. And then, you know, Mr. Marsh also raised the question that about the specific gravity of the pellets compared to the peak of water and whether they would float or sink. And he did testify that if, you know, those pellets that he verified was from that manufacturer, in this instance, they would not sink.
Well, we may have heard different parts of the testimony of the same person, because my understanding was that not only were these pellets capable of reaching the bottom, that would be the top of the packer, and having an effect on the water in the dead zone, but that the methodology that he had in place for determining the post placement of those pellets, that the methodology he had in place for testing its efficacy would demonstrate whether or not by the produced water that was returned, it was going to determine, it's going to assist in determining whether or not that is that it's working. I got that. I mean, I heard that. Did we hear different things?
I guess I would say we probably heard the same things. I just heard some contradictory information about if the well's in operation, the pump would suck the pellets back up. And that if our numbers are correct, which he didn't really dispute, I mean, he's provided the specific gravity, or his SGB provided the specific gravity of the water, and the product data sheet provided the specific gravity of the pellets. That was less than the specific gravity of the Topeka water.
Yeah, I got all that, but I also got out of it the fact that this risk factor could be overcome, that there were ways that could be overcome. In fact, just as the pressure of the gas coming up through the annulus could be overcome in a similar fashion, it could be done. And that I heard him say that he'd had experience doing it. Maybe we heard different things, but that's the gist of what I heard. Let's move on. You can respond to that if you wish. I don't mean to cut you off. Kenny, prior to this well, have you previously been a part of a dual completion application process?
No. I don't believe we've had one since 2012 in District 1.
Okay. Was that in District 1?
Yeah, that was, I don't know about the most recent. That's the most recent for District 1. I was employed in District 1, but I was not involved in that application at that time.
You know who the operator was on that?
I can't say for sure. I want to say American Warrior, but I can't say for sure.
Okay, fair enough. John, if you could, let's bring up Kenny's testimony, page 3.
I'm sorry, whose testimony, page 3?
Kenny's testimony, supplemental testimony, page 3.
One moment.
Thank you. That's good. That covers it. Let's see if it still does. You go scroll down just a little bit down the other way. A little more.
Okay.
That's fine. Kenny, can you see this?
Yes.
Okay. Let's focus on this issue of mechanical integrity and the alternative methods of providing for mechanical integrity. In particular, let's focus on basically for a moment here on lines 9 through 11, where with respect to mechanical integrity, you have a quoted portion of the regulation that in essence states that alternative test methods approved by the commission, including radioactive tracer surveys and temperature surveys, may be used to establish mechanical integrity. And then you've italicized if conditions are appropriate. I guess my question to you is, according to the staff, when are conditions ever appropriate?
For a radioactive tracer survey or temperature?
Yeah, as an alternative to pressure testing for MIT, for mechanical integrity.
The only time we run those for mechanical integrity is when there's no annular space in the well. That's been my experience.
If I go down to lines 14 through 16, is that the explanation that you've just restated, basically?
Yes.
Well, if there is no annular space inside the casing, how can there be room for production tubing?
Well, in my experience, when that has happened, in District 1 is a casing leak has developed in the well, and the tubing string or injection string was cemented inside the casing to surface. So, I mean, there was no extra, I mean, it was injecting just through the tubing.
And that was a dual completed well.
No.
Well, see, that's what I'm getting at. If we have a dual completed well, how you won't have room. I'm not seeing how the exception you're saying would be appropriate for dual completed wells applies to a dual completed well. It appears to me that it wouldn't. Your example is not for a dual completed well. No. So basically, you're saying there are no alternative methods of providing for mechanical integrity in a dual completed well. Please help me out on this. I'm becoming confused.
Also, I quoted the regulation, and as you described, I italicized if conditions are appropriate, and then I went on to describe what conditions may be appropriate for that test.
Yes, but that was not but the example you gave would not be for a dual completed well.
Correct. That's why I'm not.
But this regulation 823-407A2 applies specifically to dual completed wells.
No, I don't believe so. I believe it just applies to mechanical integrity tests.
I think that may be fair. I think that may be a fair conclusion, but it certainly applies to dual completed wells, doesn't it?
No, not explicitly.
John, would you put up the reg for us, please?
Yes, that'll take me a moment longer, but hold on.
Okay. Okay, 407. A2. Are you saying that A2, Kenny, would only apply? You're saying it would not apply to dually completed wells. Is that what you're saying?
Correct.
Really? Why isn't there an exception within A2 for duly completed wells if that were the case? That's somewhat rhetorical.
I'm trying to understand your question.
Yes, I think the point you were making in response to one of my earlier questions was that these alternative tests don't necessarily have to specifically apply to dually completed wells. And I think that's correct. I think there are alternative tests for non-dual completed wells. But I think, are you trying to suggest to me that these alternative tests, including this radioactive tracer survey under 2, does not apply to dually completed wells under 4?
Not specifically,
Are they specifically exempted?
no. Fully completed injection wells aren't explicitly exempted from 1 or 3 or 5 either. Then every 5, I guess.
Except to the extent that there are specifically different requirements contained within 4 than there are within the other sub provisions, right?
Correct, but that's not, doesn't say it's exempted from any other regulation.
But it, well, okay. Let's move on. Thank you, John. John, if you would put up can you put up page 8 of the commission's final order, please?
Yes, one moment.
That's pretty good. The only thing we've cut out is it says, therefore, the commission orders. but you've captured it there. That's pretty good. I don't know if you can just juxtapose that, but that's pretty good. It picks up ordering clauses A and B. And Kenny, we can't, I think, simultaneously put this on the screen, but I'm now looking at, again, your supplemental testimony of January 18th, 2024. I'm looking specifically at line on page 3, line 22 and 23, carries over to line 1 through 3, basically, on the next page. The essence of what it says is that, this is your testimony, it says, if the commission determines that the operator's application should be granted, then a condition of the permit should be to require the operator to pressure test the well at least every 5 years as described in ordering clause A, subsection 1. Well, here's ordering clause A, subsection 1 before us. Where do you find in there that it says that there would have to be a pressure test every 5 years?
I don't, and that's why I believe we're here today, and why you refer to subsection C.
Well, before we get to C, let's get to B.
Okay.
Because what B says, basically, is that in B 1 in particular, it says to reach general agreement, and directed the staff and the operator to try to reach an agreement. Admittedly, it hasn't happened, regarding alternative test methods to establish future mechanical integrity, with the idea that the radioactive tracer may be appropriate. I mean, I don't see any reference here to a pressure test every 5 years. Am I missing something?
No. We also recommended that a radioactive tracer survey may be conducted annually.
In fairness to you, you did. Were you present for the testimony of Mr. Lahusky in response to that proposal? I didn't hear a response.
Yes.
And what was the essence of his contention?
The cost.
Right.
we had this discussion last year, but yeah, I mean, I don't know where it says in our regulations where we can sacrifice our duty to ensure mechanical integrity of well bores at the cost of operators.
So you're suggesting that the regulations don't really provide for alternative test methods to pressure testing for dual completed wells. Is that your contention?
No, I just meant, unfortunately, I mean, the recommendation to do it annually was a recommendation, I guess, that we uphold, and you know, their dispute was that the cost, and you know, there's no regulation that requires, well, if it, you know, impacts the operator, you know, too greatly financially, it shouldn't be considered. I mean, and I don't think it's, like I said, a duly completed well in Seward County that was pressure tested annually with rig intervention annually. I mean, so like I say, I'm not asking, or we're not requesting anything egregious.
Let me turn to my final question, Kenny. I appreciate your indulgence in my questions, because I'm really concerned in trying to fulfill what I think is my duty to balance the interests of the parties here in a way that really gives some equality of weight to the testimony that's here, and tries to find which in the balance is more heavily favored. When I look through your testimony, and I want your help here to correct me, because I'm inviting you to do that, and I'm being just as serious as I can here, I find no credible discussion within this testimony of any environmental harm that arises from approving the application, subject to what I think are the fairly strict conditions that are contained within the commission's final order. And aside from your contention about this cross-water issue, about which I think reasonable people could differ, and certainly you differ with the operator on that, if I'm incorrect in this conclusion, please tell me where there's some environmental harm that you addressed in your testimony. Honest to God, I can't find it.
Okay, well, I think the issue of environmental harm has kind of been boxed into impacting groundwater. And we've all testified that, you know, there's little, if not none, threat to that usable or fresh water due to casing and cementing. I will say in the order soliciting additional testimony, there was discussion about talking about fluid or pollution prevention. And so we don't have a definition of pollution, but we do have a regulation, 82-3-104, that talks about pollution prevention and considers, you know, migration of fluid from, you know, one formation into another, and having a negative impact on that formation is something that needs to be prevented. So, I mean, it's probably all on your interpretation of what an environmental threat is. I mean, I testified last time and put it in my testimony last time that this, and I think everybody spoke to it, this is a old, well-developed water flood. It's 1962. The infrastructure is aging. And that has resulted in significant catastrophic spills that may not be directly tied to a packer or a tubing below ground, but it is tied to the injection lines and the high pressure of fluid they're moving down injection lines.
Here's the problem I have with that. We're about the process of considering the well construction that's before us and determining whether there can be environmental harm can come about as a result of that well construction. And you've just taken a giant leap into water management once water reaches the surface. That's a totally different issue. The operator is held to every standard that every other operator is held to with respect to containing water and properly disposing of it on the surface, spills and that sort of thing. That isn't really not germane to this subject at all, my friend, in my opinion, because what we're talking about is the well construction such that it could have a risk of environmental harm. And as I tried to elicit, and I think as you acknowledged, frankly, just within the last few minutes, as I tried to elicit from Mr. Lahusky, we have a lot of surface casing in here. That's been cemented in. There are a whole number of factors about this well construction that isolate fresh water from the operation of the well, such that that is not really an environmental risk. That's why I'm having a heck of a time trying to find something that's an environmental risk. I just can't conjure up anything that is. Do you understand that?
Can I object?
You want to object to me?
I mean, I'm just not, I would like to hear a question. I feel like this is starting to get argumentative and not necessarily asking cross-examination.
Well, maybe if I had a chance to finish what I was saying, I could get to the question then, Kelsey, in all due respects. So Kenny, I'm not being able to see where it is that how I think you're conflating water management on the surface now with the protections to the fresh water provided by well construction. Am I wrong? Is that a question, Kelsey? Kenny, that's a question.
Oh, I'm sorry. Sorry. I believe, like I stated, I mean, I don't want to put words in your mouth, but you seem to be the environmental concern is just impacting groundwater.
Well, what I don't want to do is conflate water management and that responsibility once water reaches the surface with the construction of the well in determining whether or not we're going to deny this application, because they're two separate subjects. You follow me?
Yeah, but I do, and I've been hesitant to raise the issue. But I mean, is there zero environmental threat? It would be up to your interpretation of what that means. Soil pollution to me is an environmental threat, and if you allow me, I'll just leave it at that.
Well, how is soil pollution affected by the construction of this well?
By the construction?
Yeah.
Well, it's a high pressure injection well, which means that another high pressure line will have to be run to the well on this flood that has seen 22 spills over the course of 5 years.
But that's still a surface water management issue, isn't it? That really, you know, if there's a break in a water line before the water reaches the point of injection, that's not to condemn the well because it failed in some way, is it?
No, but would it have happened if the well were permitted?
If the well didn't exist? Well, I mean, that's an interesting hypothetical. Can I appreciate your indulgence in my questions? The only reason I was trying to be a little more dispositive in the way I'm asking my questions is because I'm really trying to get to the core of this issue. And if I can lay a foundation for doing it, that's why I'm doing it. Thank you. I appreciate your indulgence. That concludes my questions of Kenny at this time.
All right. Commissioner Keither, do you have any questions for Mr. Sullivan?
Not at the time. I mean, my head is spinning here. There's a lot to absorb.
I'll give you some time to spin. Good afternoon, Kenny. I've just got a couple, I think, clarifying questions for you. I'm trying to decide where a lot of what I was thinking I might address with you, I think has gotten addressed in other ways. Let me ask you one really limited item first, because I don't know if your council is planning to bring this back up. With regard to some of your criticisms of the chemical program, I think your council brought up a data sheet for some of the pellets that were to be used, and that the specific gravity of that product was going to cause it to float on the water. And I think at least my understanding of the response from the witness from Merritt was, yeah, if that's the same product, that is what would happen if those are the specific gravities. Have you spent any time reviewing that data sheet and reviewing the specific product that they are planning to use? And do you have anything, any experience to add on that? Because it seemed to me that might be something we need to lock down.
Yeah, I mean, I reviewed the chemical analysis that was an exhibit in the previous hearing from Mr. Lahutsky that, gave the full chemical breakdown that I think Kelsey shared earlier, that had the specific gravity of 1.6. And then the CIP-25 corrosion inhibiting pellets manufactured by Select Industries product data sheet, said gave a range of the specific gravity of the pellets that were less than the specific gravity of water. So, if it's more dense, you can't sink. I guess I've raised questions through hearing, what is the mechanism? I mean, let's say they do sink, how do they treat the water as they go up? Or what, and I don't know that that's been answered either. I can't speak to that. I've never bought corrosion inhibiting pellets or used them or anything. So, I mean, just questions I've raised that haven't been answered.
Just to drill down, I mean, I think the questions are raised now. But I want to be clear. I mean, did you confirm that is the same product of pellet? Because that seemed to be the crux of the issue.
I would think Mr. Moorhead would be the one to, determine that. He didn't seem to. I mean, I didn't see that he argued that wasn't the. I mean, I'm not about trademarks and naming stuff, but I mean, I can't imagine multiple. I mean, CIP-25 seems pretty specific and
yeah. So at the very least, if we were to grant this or find that the chemical program satisfied us, you would probably want to see some sort of condition confirming that the pellet that is going to be used isn't going to float, right?
Right. And they've discussed the 4-prong approach, and I mean, I think on Mr. Moorhead's, last line of his January 24th testimony, he his last sentence, well, before his last question anyway, on page 4, starts on page 4, bottom 29. Even if those circumstances came to fruition, the chemical program could be modified to overcome them, but doesn't offer any way how. I mean, I assume they're presented their best plan of attack to. So if there's a solution past that, I guess, why not offer that?
All right. We'll give that some more thought. I want to jump to a different area. It seems like there's been a lot of discussion of staff's recommendation that, not only should we do an MIT, as initially as a condition to granting the application, but we should do one every 5 years, a traditional MIT. And I know, there sort of were a number of reasons Mr. Lahutky gave for why he didn't want to go there. I'm trying to recall. I mean, I know there was the cross flow issue of each time you open it up, you're going to potentially have cross flow. There was the wear and tear on all the equipment. I know it's sticking in my mind. They talked about that the location of the well is on federally managed grasslands, national grasslands, and they would have to bring in a lot of equipment to do that full MIT, and so there'd be more disturbance. Can you talk about, and obviously they've brought up there's a lot of economic cost as well. Could you talk about how big the benefits of a traditional MIT are compared to monitoring fluid levels and water to gas levels compared to all those drawbacks? I mean, how did the staff view sort of the cost benefit analysis there?
Yeah, so I guess, you want me to start with how the staff view the cost benefit analysis of the deal?
Yeah, why? I guess, yeah, all I'm asking is why was the every 5 year traditional MIT so important to staff to add that in?
Yeah, I think it gives us a full picture, a full range to determine mechanical integrity of the wellbore. That is otherwise, maybe questionable at best. I think you did reference it in our petition for reconsideration. We raised the peer review by the GWPC, and what they said is that the division. Did you read that? I don't need to read. Did you read the full?
I don't have it in front of me, and I haven't read the full report for quite a while. So go ahead.
Bullet point 8. It said division should consider phasing out any permitting of dual completion wells that are used for both production and injection, because tests for mechanical integrity of these wells has not been shown to be an accurate means of evaluating well integrity. So these alternate test methods have been shown to, not been an accurate means of evaluating well integrity. I would argue that with that, it might be beneficial for the operator to pull their tubing and packer and inspect it and redress their packer if they need to, get eyes on it. It's hard to predict what's going on 4,000 foot below ground. I mean, so I would see that it's probably a benefit to get eyes on that every now and then, every 5 years, I guess, to see that, and then we can ensure. I mean, there shouldn't be any doubt at that point that well has integrity.
So I guess I'm truly just asking your opinion here. If we're trying to balance costs and benefits, I mean, I guess the way I'm seeing it in my head is there's an incremental, the traditional MIT is incrementally better than our other methods of being able to monitor fluid levels and gas to fluid ratios. I don't know, because I'm a novice, is I don't know how much incrementally better is it, and is it worth making somebody spend $25,000 every 5 years, and is it worth the risk of cross flow, and is it worth the risk of damaging when you pull all that out? I guess if you don't have anything more to add, that's fine, but if you have anything more on how I make that value judgment, or you could defer to Mr. Kloss or Clock or Mr. Morris.
Yeah, so unfortunately, there's not any regulation on what we determined. Well, if it costs X amount of dollars, we don't need to concern ourselves with this. I mean, we have a regulatory task assigned from the EPA, to oversee our Class 2 injection program to ensure that these wells maintain mechanical integrity.
But let me say here, Mr. Sullivan, I'm probably the least concerned about the $25,000. I understand that may be the biggest concern to the operator, and it may make or break the operation. But there's a lot of different risks listed, so I don't want to focus too much on that.
Okay, so I think you brought up like all the equipment needed for the ground or on the ground for the MIT.
Mhm.
That being an issue. I mean, once again, not something we say, well, we'll sacrifice this wellbore mechanical integrity because we'll two-track up around the lease. That would definitely be a civil matter. That's considered. I will say, with any pump and power swivel and all that stuff to drill out the plugs, they're going to have significantly more equipment on location for recompletion than they would an MIT, or maybe not significantly more, but more equipment out there, and that seems to be acceptable at that time. Same with the crossflow. I mean, I've testified to it during drilling out. That Topeka is gonna start taking in water in Wabunsee. They talk that crossflow is not a big deal. There's no. I mean, the Topeka is a limestone formation, just made up of natural fractures. And yes, it does produce some water, but the Morrow is a sand, and it brings fines with it, sand particles in the water. I mean, you can't separate that in the wellbore. So that material is coming up. All that material is going to invade. I mean, there's going to be a massive influx of foreign water. I think I put in my testimony, I listed out like 6 different regulations that kind of explicitly discuss how that's not good and that needs to be prevented and mitigated. That's going to happen. And I mean, I think the lack of reservoir compatibility, the amount of fluid, I mean, is going to be pretty a lot. It's going to be pretty exceptional, the amount of fluid that enters that wellbore, and that possibility of damaging that formation is there.
Okay, yeah, and I think you and Mr. Schlatter went around about that, and the issue of do you do it once, and if you do it once, do you want to do it every 5 years? And I totally get that. It sounds like it's just something we need to take under advisement and think about. Since you mentioned the Groundwater Protection Council report, I mean, I did want to address that with staff. Again, give you the opportunity to add more maybe color about how you're thinking about it. I have to admit, I'm troubled by not pursuing sort of peer review recommendations. But the counter to that is, in this particular circumstance, I think everybody is in agreement that groundwater is not an issue given the particular well construction standards. So I guess, would you have anything to add as to anything specific about the geology in this area, why we may want to just, I think in Mr. Schlatter's words, I think he viewed staff as just wanting to not ever approve any more dual completion, injection and production wells in the future per that recommendation. I mean, do you think that's appropriate for Kansas, or are there some exceptions in certain circumstances where the facts show us that groundwater isn't at risk?
Mr. Chairman, if you would, pardon my interruption, please. May we have an executive session?
This is my final question, Mr. Sullivan. So maybe could I get an answer here, and then we just move into executive session?
Well, but my concern has to do with the report of the GWPC.
Yeah.
Could you maybe give me more information?
I would request an executive session with yourself and Commissioner Keither and council.
Why don't we let Mr. Sullivan answer the question and then we'll go into executive session? Is that, if that's okay with you?
It causes me concern.
All right, let's I guess let's go into executive session and we'll try to figure out what this is all about. And then we'll return. So right now we're going to go off the record. John or IT staff, if you could give us a breakout room, we'll do that, and then we will return.
Sounds good. Working on it now.
I just did it, Sean. So we've got a room now.
Okay. Perfect.
And I think the three of you can join. Yeah, and I'll be there in a moment.
All right. Michelle or Sean, I don't know who we've got, but we're back from our breakout room. Or at least I am. Wait for Commissioner Keither and for John to pop back up here.
Commissioner Keither will join us in just a moment.
Okay. Actually, we've been going an hour and a half. I wonder if everybody would appreciate a short break. Do we want to just take a 5-minute break for everybody to take a bathroom break, go refill your coffee cup, maybe 3:05? Does that sound okay to everybody? All right, 3:05 we'll reconvene. John, I presume you'll let Commissioner Keither know if she pops
Yeah,
back
I
in.
will. Absolutely. Commissioner Keither, in case you didn't hear, Commissioner French just called a 5-minute break, so we'll be back in 5 minutes.
All right, I believe we are all back. I'll wait for a couple more people to come on camera. Okay, looks like we've got all the relevant parties back in the virtual room here. So we are back on the record in this hearing. Mr. Sullivan, I'm going to try to recall where I was with the questioning. I think we were talking about the GWPC report, and the gist of, I think, what I wanted to get at was sort of there's this recommendation that we phase out sort of all dual completed, dual being injection and production wells. And it says specifically due to sort of the inability to effectively test well integrity. And I guess my question was that, it looks like all the parties for this specific application are in agreement that groundwater is not an issue. It's not a threat in this case. And so I was sort of just wondering if you kind of agreed that that recommendation may not be applicable to this particular application, or is there something very specific about the geology in that area that would make it applicable to this situation?
Yeah, so I mean, it's called Groundwater Protection Council, and it probably says what it means, or that's their primary responsibility. I mean, this specific report was, a peer review of our class 2 UIC program. So I think it's more multifaceted than focusing on just strictly groundwater. But I mean, to answer your question, I think where the unique geologies come in is just the commingling of the Morrow and Topeka limestone that, wouldn't likely cause any impact to our groundwater.
Yeah, that's helpful. I think that's what I needed. I don't believe I have any more questions for you. Are there any follow-on questions from commissioners before we go to redirect? I'm seeing a no from Commissioner Keither. Commissioner Keen?
Yes, if I could, Chair French, thank you.
Go ahead.
Kenny, just one follow-on question from me. Again, having to do with this groundwater protection report. This had to do with class 2 wells, UIC wells. The report itself is dated September 2020. And I guess my question to you is this: are you aware that on page 39 of this report, the report states that there are no known problems with any dual completed wells that currently exist in Kansas? Are you aware of that?
Yes.
Page 39.
Sorry, no, I was not aware of that report. I guess I would refute and say, though, there is no duly completed wells currently of this completion either.
All right, thank you. That's the extent of my questions. Thank you.
All right. Let's see. What are we ready for? Redirect, Mr. Marsh.
Thank you, Chair French. Hey, Kenny. First thing I want to take care of is what staff's presented as KCC Supplemental -1. Have you conducted research regarding CIP-25 pellets?
Yes.
And were you able to find a product data sheet for the CIP-25 pellet?
Yes.
I'm sharing my screen now. Is this that product data sheet?
Yeah, that's the one I found.
I would ask that we be able to admit KCC Supplemental -1 into the evidentiary record.
Is there any objection?
This was not provided to me before this hearing, and what's being offered is factual evidence.
I'm sorry, I can send it over to you.
Well, it's a little late now.
I see we have Mr. Moorhead still listed on the Zoom. I've got some concerns with whether we have enough foundation to know whether this data sheet is the exact product that Mr. Moorhead described. I think he had some questions about that in his own responses. I wonder, would it be possible, Mr. Marsh, to send this to Mr. Schlatter and Mr. Moorhead to allow them to review it? And then if it's possible, could we bring Mr. Moorhead back up on the stand to get some more foundation on this? I obviously said in my questioning that I thought it would be important to nail this down. Would anybody have any objection to giving Mr. Moorhead a little time with the data sheet? And then for us to ask him a couple more questions about it? Mr. Marsh, Mr. Schlatter, you okay with that? I'm seeing a thumbs
That's
up
fine
from
with me.
Commissioner Keen.
I would like to be able to do a little bit of my own direct on it because I discussed the issue of weight of the pellets, and I believe this issue is very easily resolved with simply using heavier pellets. It's gravity. So if you're inclined to let me recall Mr. Moorhead, we can knock this out in about 30 seconds.
We will do that. Let's plan to take Mr. Moorhead after Mr. Sullivan's done. I don't want to make him wait till the very end of the day. Is that okay with Mr. Marsh and Mr. Schlatter?
That's fine with me.
Okay. And Mr. Moorhead, I see you've gone on camera. I appreciate that. Good to know you're still there. Mr. Marsh, if you would get that document sent over to them, I would appreciate that because I think it does warrant, I think it's relevant information. We just need to make sure we know what we're looking at.
Okay, I've already sent it to Mr. Schlatter. I don't know that I had Mr. Moorhead's email address, so I will count on Mr. Schlatter to forward it on to him.
Yeah, very good. All right, Mr. Marsh, any additional redirect beyond the data sheet?
Yes. Kenny, I know we've mentioned monitoring the gas to water ratio in the casing of the well. Is that just a measure of the gas and water coming up from the wellbore, or does that actually test the casing in the well?
It's just a measure.
Whenever staff is monitoring wells for mechanical integrity, does staff have more control over the witnessing process of pressure tests, or more control being provided gas to water measurements from an operator?
Pressure test. Our district, we witness every MIT.
I know earlier on there was talk about cement tickets. Has Merit provided cement tickets of the surface casing?
I don't believe so. I don't know that I've seen.
Is there a way for them to verify that there is adequate surface casing cement?
You'd have to rely on cement tickets at this time. So, I mean, technically you could run a bond log, but you can't do that with the production casing in the hole. So you rely on, I guess, cement tickets and ACO1s.
There's also been a lot of discussion about radioactive tracer surveys. Have you ever seen a radioactive tracer survey test fail?
I've seen one.
In what instance did it fail?
It failed. It was actually on one of our legislative contamination sites that the well failed it originally failed and contaminated the Ogallala water in Morton County. And so, they needed to start a recovery system on that. So what they did was they, like we talked before, they cemented their tubing into their wellbore and still maintained that wellbore for disposal of their recovery system. And that leak was developed in the Ogallala again. So, with the use of a radioactive tracer survey, we also had the risk of injecting that radioactive material out into the freshwater formation during that MIT. So that is the one time that leak was pretty catastrophic for that test to pick it up.
Okay. I know we've talked about alternate test in 82-3-407A subsection 2. Now the regulation states that an alternative test may be used if the conditions are appropriate, correct?
Correct.
Do you believe that the conditions at this well are appropriate for a radioactive tracer survey as a substitution for the MIT?
No.
And I think the last question I have is, I know you talked a little bit about spills here in your testimony today. Can water management on the surface be reflective of how things are being managed below ground as well?
I suppose. Yes.
I think that covers all my questions. Thank you.
All right, any need for any recross? I'm sorry, Mr. Slatter, your microphone's not getting you again. Keep trying and make sure you don't have any papers or anything covering it up, but just keep plowing ahead. It seems the more you talk, the more it gets familiar with you.
I actually have no idea where the microphone is on this thing. But I'm sure it's there because it works when it feels like it. Just a few questions for Kenny here. When you say that radioactive tracer test failed, do you mean the test itself failed and failed to identify a casing leak, or that it actually identified the casing leak?
It identified the casing leak, so the MIT failed.
So the tracer test worked in identifying the casing leak?
I believe, yes.
Okay. We're going to talk about the pellets and, if they're not sinking, what can be done to sink them with Mr. Moorhead. So I don't need to ask you any questions about that. But you did say that you had all these questions that you'd raised that you wanted answers. When did you raise these questions?
With who? I raised them in the last hearing. Like I said, I made a silly Kool-Aid analogy. That's still a question I have, is how, if they do sink to bottom, how do they treat the full water column?
So during your testimony, you raised, this wasn't, for example, the final order directed you to meet with Merritt and come to an agreement on a chemical program. Did you discuss those questions then?
I did not meet with, I think it directed staff to, and a staff member did.
They asked that question.
I'm sorry.
The reason I'm asking is the first time I've ever heard of this was during testimony today. I'd never heard this question before. I'm wondering if it was actually raised for the first time today, or if this question was asked of Merritt's staff and no one answered.
The question of how will the pellets treat the column of water?
Well, I think specifically how they'll sink to the bottom and treat the column of water, but maybe I'm splitting hairs there. Was it? Yeah. Because the first time this question got brought up during this hearing, and I'm not talking about testifying about it in passing. Did you ever actually ask this question of anyone of Merritt?
No.
One thing you mentioned that it might be good to pull the well every 5 years to get eyes on it. When a regular injection well gets pressure tested, do they pull the well?
They don't have to unless it fails MIT. To do a pressure test on this well, they have to pull it.
Well, that's not really what I asked. How many injection wells are there in Kansas that are single completion?
Thousands.
And when they do a pressure test, do they pull the well to get eyes on the equipment?
No, but they are testing the equipment.
When they pull the well, they're testing the equipment.
No, when they do the MIT, the standard annual pressure test, MIT, they're testing the equipment.
I guess where I'm going is what benefit is it to get eyes on it in your scenario? I don't understand. If 9,000 wells are pressure test without pulling the well, what benefit is there to pulling this well to look at it?
That was one of the pluses. I mean, I don't understand how it harms the equipment pulling it either. So, I mean, it's probably just that.
You don't understand how pulling 4,000 feet of pipe out of hole could possibly harm it.
Right.
Okay. One thing I think Merritt deserves a little credit for, and this is my last question here, is Mr. Lahusky previously testified in the original hearing, specifically in his rebuttal testimony at page 24, page 6, line 24 to page 7, line 21, that Merritt had replaced all of the line surface.
Or do you want to pull it up, or is it that detailed of a question?
I'm just wondering, you
Well,
about how old the surface equipment was, but Mr. Lahusky testified in this docket at that cited page that they'd replaced all those lines with new lines, new fiberglass lines.
okay.
You were aware of that?
Every single line on this water flood unit? No, I was not aware of that. I know they replaced some.
Okay. That's all I have for Mr. Sullivan. Thank you, Kenny.
Any further commissioner questions or redirect? All right, I'm not seeing any. Okay, Mr. Sullivan, you may step down virtually. Thank you for your time. Mr. Schlatter, let me ask you, are you and Mr. Moorhead prepared to address the pellet issue yet, or does Mr. Moorhead need more time to look at that data sheet?
I'm gonna roll the dice and say he's probably ready to go.
Okay. All right. Well, then I will let you. What I'm going to do, Mr. Marsh, I know this was prompted by you, and this was your exhibit, but I do want to find a way to get this into the record and then get some testimony on its relevance. So what I'm going to do is I'm going to let Mr. Schroeder call Mr. Moorhead. I think what I'm going to allow, because it's going to just be quicker. I'm going to let Mr. Schlatter do a little direct examination of Mr. Moorhead. And then if you want to cross-examine on the exhibit, I'll allow that. I hope that's acceptable. I'm not even going to ask folks whether it's acceptable, because that's what we're going to do. So Mr. Moorhead or Mr. Schlatter, call your witness, please.
Calls Mr. Michael Moorhead.
Mr. Moorhead, please raise your right hand. I'm going to swear you for the third time today. Do you swear to tell the truth? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, thank you. Mr. Schlatter, go ahead.
Thank you, Chair French. I suppose I could publish that, but let me do a little bit of background here. Mr. Moorhead, earlier during your direct testimony, during your initial round of testimony, staff had asked you a question in reference to the gravity of the water as demonstrated on a 2022 water analysis compared to the gravity of the pellets, with the implication being that if the pellets had a lesser gravity than the water, that they may not sink. Do you have a response or an explanation of how that might work?
So with that specific gravity question, there are options for more weighted pellets designed to fall through heavier brines. One thing that I don't have access to right now, but I'm going to do additional research on, is if that's the specific gravity of the quat that is blended and solidified into the pellet, or the weight of the pellet itself. It would seem strange to me to typically specific gravity is the density measurement of a liquid. You would not measure a solid with a specific gravity because it's a solid. There is no, it's all specific gravity is relative to water, where the specific gravity of water is 1. Anything that's heavier than water is greater than 1. Anything that's lighter than water is less than 1. So it wouldn't make sense to measure a solid in a specific gravity. And so that's something that I'm going to educate myself on with that product data sheet. If that is the case, then we would move to a weighted product that is specifically blended with that solid chemistry to add additional weight. So typically different heavier water-soluble mineral salts to allow it to fall more efficiently to bottom.
Well, I can kind of follow up on that, and I think I'm understanding you correctly. Your question is that, or what you're intending to research is whether that gravity indicated on that form is indicative of the pellets as dissolved, or what they actually, or some weight factor.
Correct. When we pelletize solids, essentially we would drive off any available liquid and then encase that in a water-soluble salt, basically. And so typically for SDS's purposes and product data sheets, it will list as a specific gravity. This is the specific gravity of this chemistry, so that if there is some kind of spill or something like that, or when you have this dissolved in liquid, you know what it's going to do. And that's something that I'm going to research with that particular manufacturer, because I am unaware of exactly the precise definition of that.
My understanding, the monitoring program that SGB Solutions would implement, if those pellets were floating, would those be observed in the water samples?
Yes, we would see an inordinately high corrosion inhibitor residual. So we would know that something was amiss there, because they would be floating on top of that close to the suction of the pump. So we would see that.
That addresses the issue, but of course, Mr. Marsh has the right to conduct cross, but that's all I have for Mr. Moorhead.
Well, let me ask Mr. Marsh. I think we have information probably allows us to accept the document as an exhibit, subject to now we probably have more information around how we want to treat it and the weight we want to give it, or what we want to do about it. But I will, so I think I will go ahead and admit it right now. And what could you, Kelsey, just say what the exhibit number was?
I identified it as KCC supplemental -1.
Okay, so KCC sup 1 is admitted. Mr. Marsh, would you like to do any additional cross-examination based on the direct examination that I just allowed?
I guess the only question I might have is, Mr. Moorhead, did you ever look at the product data sheet for the CIP-25 pellets?
So the information that was given to me by Select Industries. That was something that prior to writing this, we wanted to make sure of as a form of, if it would dissolve, what the bottom hole temperature would affect, how it would affect its dissolution. So I did speak with Select Industries, but I did not see that specific data sheet. No.
Okay. I think that covers any questions I have. Thank you.
Very good. And just to check, do we have any commissioner questions on this topic? Commissioner King, go ahead.
Yes, thank you. Just one briefly. Mr. Moorhead, I think we're really concerned about the efficacy of the placement and the placement of this pellet because of the kind of a critical issue that it's become in this case. So my question is kind of a follow-on to the direct examination and Mr. Marsh's question is this, very simple. Is there any way we can have any assurance, or can you give us some assurance, that these pellets, once displaced, won't simply be sucked back into the pump and pumped to the surface unexpended?
Gotcha. Speaking with Select and my understanding of how the pellets dissolve, they typically will dissolve in a span of anywhere between 30 minutes and 2 hours at the bottom hole temperature estimated there. I believe it was in like the 120 to 130 degree range. That puts it a little bit closer to that 30 minutes to 1 hour. Once I completely agree with you that, you know, placement of the chemistry, if it can't get where it needs to go, then it's not going to be effective. And that's why we want to dig more into this concern. And if a product change, kind of what we were saying similarly in my testimony, if a product change is required, we can absolutely facilitate that. And that's not an issue. To ensure that these are well above the weight, as well as, you know, that will fall, sit on the top of the packer, dissolve, and disperse throughout that fluid column, protecting that dead zone.
Thank you.
All right. If there are no further questions, Mr. Moorhead, I'm going to release you and let you step down. I hope for the last time today, but we do appreciate your indulgence. With that, Mr. Marsh, you may call your next witness.
Thank you, Chair French. Commission staff calls Jeff Clark. And if we can have somebody change the name from Kenny Sullivan to Jeff Clark, please.
Good afternoon. Can everybody hear me okay?
We hear you, Jeff. Oh, and they've got your name changed. Great. All right, Jeff, if you would please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Go ahead, Mr. Marsh.
Thank you, Chair French. Can you please state your name for the record?
It's Donald Jeffrey Clark. I go by Jeff.
And Jeff, by whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission as a professional geologist supervisor in the District 2 office.
And what is your work address?
3450 North Rock Road, Wichita, Kansas.
Are you the same Jeff Clark who caused to be pre-filed in this docket supplemental testimony consisting of 4 pages on January 18th, 2024? I'm sorry, I didn't hear a response.
I'm sorry. Yes.
Okay. Was this testimony created by you or at your direction?
Yes.
Now that you're under oath, do you have any corrections to make to your testimony?
Just a clarification, if I could. It would probably clarify things for everybody and speed things along. On page 3 of my testimony, question 10, and then lines 12 through 16. I just want to clarify that I did understand that the commission's final order issued by the commission did require the initial testing of the wellbore, and that it was not required every 5 years.
Was the 5 years just to support Kenny's testimony or recommendation that one be conducted every 5 years?
That is correct.
Okay. Do you have any other corrections or clarifications to make?
No.
Do you swear that the answers contained in your pre-filed testimony are true to the best of your knowledge?
Yes.
And if I asked you the same questions contained in your testimony today, would your answers be the same?
Yes.
At this time, staff moves for the admission of Mr. Jeff Clark's pre-filed supplemental testimony from January 18th, 2024 into the formal record.
Sorry. Is there any objection? Hearing none, the reference testimony will be admitted.
Thank you, Chair Branch. At this time, staff tenders the witness for cross-examination.
Okay. Hunter, do you have cross-examination for this witness?
I can't. There we go.
Yeah. Keep talking because your microphone's not getting you yet.
Doesn't turn yellow when I'm talking, and then it picks me up.
Got you now.
When it's not hearing me, at least. Hello, Jeff. How are you today?
Doing fine, John.
I had a question about the cement tickets in your testimony. You said that the operator needs to turn in the cement tickets. You understand that Merritt didn't drill this well, right?
Right.
That it was drilled, I think, in the 50s by like City Services or somebody.
It was City Services. I'm not sure of the year, but you're correct. City Services, yes.
Okay, so it's highly likely these cement tickets are lost and lost forever.
Very likely.
And so would the cement bond log that Merritt runs be an acceptable substitute for those?
That is correct. I have operators that do convert old well bores, and they do ask what requirements they will have to meet. And lots of times when somebody is wanting to convert an old well bore, they don't have the cement tickets, and therefore we do require the bond log in lieu of having those.
Okay, well, that's all the questions I have.
All right. Well, then we will turn to commissioner questions. Commissioner Keen, I'll go to you first. Do you have any questions for Mr. Clark?
Good afternoon, Jeff.
Good afternoon.
I have no questions for Mr. Clark.
And Commissioner Keiser, do you have any questions?
I just want clarification. You're saying that you don't support the need for every 5 years in your testimony that you said you did?
I do, yes. Yes. I did understand the commission's final order did not require that, but I am supporting staff in that, and I can go into more detail in that if you'd like for me to.
That's fine. Thank you very much.
Well, I'll go there with you in just a second, but first, well, good afternoon, Jeff. I'm going to stay on the same themes you've already talked about. Now, on the cement bond log, you don't have that yet, right? So we're going to need, they'll do it once it happens. Do you automatically get that, or does that need to be added as a condition of this application that it be provided to you?
That it provided to the UIC department. Again, I'm in the district office, but yes, provided to the UIC department as a condition of the permit. That is correct.
Okay, so you would support adding that as a recommendation. Okay. And then on the last issue, you know, I got Kenny's take on it, but I guess I want your whatever color you can add to the whole, you know, if we were to grant it, should we do a full traditional MIT every 5 years? And I know I'll just give my quick description again. You know, it seems like there is an incremental benefit to doing it, and then and I'm not sure how big that increment is. And then there's all these drawbacks against that benefit. And so I just would like your thoughts on what the balance is there on the benefits and the drawbacks.
Sure. And you know, the methodology that I've heard today, I don't have any issues with that. I'm not going to testify as any type of a chemical expert, of course. But with the unknown, again, without having cement tickets or a bond log, and I hope we haven't wasted a lot of time here today, and that the bond log does support the application, but until you run the bond log, you don't know. There's unknowns out there. We don't know if it will support it, if it will support this application. But given the construction that they believe that we do have, you know, a gap. That's my concern, that it's a little it's an old wellbore being converted, a little unconventional for for what I would suspect to be a duly completed. Again, we don't have but 3 of those in our district that are historical. I'm supporting the mechanical test every 5 years. And the reason for that is if you do it at the start, that's the only mechanical integrity test you'll actually ever get at the casing. The flood levels, absolutely. That's great monitoring. It's the thing about that is if you find something amiss with a flood level, you're being more reactive than proactive. And that mechanical integrity test every 5 years is going to ensure that those portions of the casing, again, we don't have the bond log being cemented, uncemented, partially cemented, that casing does have integrity. When we're talking about, let's talk about the flood levels for a second. Those are also a great way. I know we spent a lot of time talking about tracers today, but your flood levels that you shoot in the annulus and down the tubing, you're doing that in a static condition where that well has been shut down for a 24-hour period. So another function that also performs is you're going to get a flood level in your annulus, and then you're going to get a flood level in your disposal string. Those should be different. Casings, that's, it's saying that the casing has integrity. You should have those should be reflecting 2 different flood levels. After being in a static condition, those flood levels are the same. It's telling you've got something communicating. You probably have a tubing leak at that point in time. So there's other functions for that flood level shot. I know we focused on a lot talking about casing leaks, but it also is a function for testing or determining if you have a possible problem with your tubing. I know we concentrated a lot on the tracer survey, but I wanted to add that as well as a function for those flood level shots as required in the regulations for a duly completed well.
Yeah, and I mean, you can tell that's just what I'm struggling with. I'm in a complete agreement with you that it seems like we are going to get a lot of information from the fluid level tests, from it's been described, the gas fluid ratio tests, and I am hearing, there are a lot of drawbacks to pulling equipment and doing the full MIT or risks associated with that. And so it's just that balancing test of how much is that incremental benefit. Do we want to do it every 5 years? Do we want to do it a longer period? Is it better to leave it alone once it's in there? I don't know that, there's a lot of conclusive evidence to guide us on that. So, but I do appreciate, the extra color you're able to provide around sort of the various tests and, the value that we're going to get out of them. With that, I don't think I have any more questions. I'm looking at other commissioners. Mr. Marsh, do you have any redirect?
I think I have one redirect question, Chair French, if I may.
Sure, go for it.
Well, maybe 2. Jeff, how long have you been with the commission?
Yeah, almost 29 years.
And have you ever received any sort of training on when a radioactive tracer survey would be appropriate?
I have.
And what was that training like?
When I went to I started off working in the central office in the production department, and then in 2000, I think it was 2000, I went over as a geologist to the district office, and when I was trained on our various MITs and talking about when we use this test or this test or this test, definitely, yeah, I did get trained at that time on the alternative methods, well completions, the different types of well completions, and what appropriate MIT was used for those various tests, or well completions, I should say.
And I'm sorry, I may have missed it, but what kind of well completion types are appropriate for an alternative or radioactive tracer test? Excuse me.
So radioactive tracer test is actually for a tubingless completion. And when I say a tubingless completion, it was actually designed for those wells, like over in District 3, where we have a small amount of surface casing, and the tubing is cemented top to bottom. And I use that word tubing, but actually it becomes casing. Technically, it becomes casing. When that is the only string that is set and cemented bottom to top, it becomes casing. We also historically had wells that the casing was cemented bottom to top, whether it be 4.5, 5.5, 7-inch casing, and water was disposed directly down the casing. The radioactive tracer survey was actually designed to be used in tubingless wells where the casing then could be tested. What the tracer does is once it seeks a hole, it's gonna hang up there. Some of that radioactive iodine is going to hang up there. And you can run your tool back up through that, and you can see that it's not following that slug of radioactive iodine as it gradually goes down the well. You know, it's eventually going to seek the path of least resistance down the bottom of the well or casing in the case I'm describing.
And those well completions that you described, that's not what we have here in this case, is it?
No, it's not.
Thank you. I don't know that I have any further questions.
All right. Before we finish, Mr. Slatter, any recross necessary? All right, I'm seeing a nod. Go ahead.
I think there it goes. Jeff, if that's true about those only being the select circumstances when radioactive tracer testing is appropriate, then why do the regulations allow it as an alternative method for all injection wells, including duly completed wells?
The regulation says if conditions are appropriate, and historically, I believe those to be if it was a tubingless completion.
Why would it say conditions if it was just for tubingless completions? That's a pretty specific.
True. You got to remember these regs were written when I was a junior in high school, so they were probably I'm assuming they were a product of the Safe Water Drinking Act and encompassing, you know, can we test these wells that don't have an annular space in them? What's an alternative method that we can use? Am I saying you can't use it on a duly completed well to ensure that your tubing has integrity? No, I'm not saying that at all. You can do that. And I do have operators that do run tracers down their tubing just to ensure they have integrity.
Thank you.
All right, you cut out there a little bit, but I think Mr. Slatter indicated that was all he had, and he thanked Mr. Clock. Any redirect necessary or commission questions necessary? All right, very well. Mr. Clock, thank you so much for your time. You may step down virtually.
All right.
Staff, you may call your final witness.
Thank you, Chair Branch. Commission staff would call Case Morris to the stand. It may take a little bit for the video to catch up and for him to make it to the computer.
All right, I see we have Mr. Morris. Good afternoon, Case.
Good afternoon.
All right, if you would, please, if you're ready, please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Mr. Marsh, you may proceed.
Thank you, Chair French. Can you please state your name for the record?
Case Morris.
In case, by whom and in what capacity are you employed?
Employed by the Conservation Division of the Kansas Corporation Commission in the District 4 office as a professional geologist supervisor.
And what is your work address?
2301 East 13th Street, Hayes, Kansas.
And are you the same Case Morris who caused to be pre-filed in this docket supplemental testimony consisting of 3 pages on January 18th, 2024?
Yes.
Was this testimony created by you or at your direction?
Yes.
Now that you're under oath, do you have any corrections to make to your testimony?
No.
If I asked you the same questions containing your testimony today, would your answers be the same? I'm sorry, I didn't hear you. Can you try one more time?
Yes, can you hear me? Okay.
Yeah. And do you swear that the answers containing your pre-filed testimony are true to the best of your knowledge?
Yes.
At this time, staff would move for the admission of Mr. Case Morris's pre-filed supplemental testimony from January 18th, 2024 into the formal record.
Any objection? Hearing none, it will be admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
All right, Mr. Schlatter, any cross for Mr. Morris?
One question, there it is. One question for Mr. Morris, and that is, Mr. Morris, you aren't here presenting today in any capacity as an expert in a chemical program, are you?
No.
It's the only question I have.
All right, we will move to any questions from the commissioners. Begin with Commissioner Keen again. Do you have any questions for Mr. Morris?
Good afternoon, Case. Been a long day in Wichita, huh? Just one question from me, Case. If we take a look at the reg 823407A2, with respect to mechanical integrity, and I'm quoting here, it states, alternative test methods approved by the commission, including radioactive tracer surveys and temperature surveys, may be used to establish mechanical integrity if conditions are appropriate. By my reckoning, you've been with the commission for over 35 years, haven't you?
33, 34 years in there.
Sorry, I didn't mean to make you older than you were. So my question to you is this. With respect to dual completed wells, when are conditions ever appropriate?
Even where it would be really conducive to do a radioactive tracer survey.
Why do the regulations provide for it?
I don't know.
Well, that's an honest answer. I'm pretty much guessing that it was a hot topic of the day at the time it was adopted, and that's been some time ago. And I'm going to guess that it was vetted to some extent at the time it was adopted. It wasn't just simply pasted on. But how many dual completed wells do you have in District 4?
I think we have 4 or 5.
What are the general requirements here as far as retesting on those wells?
Generally, we have them do the fluid level, which is required, and the oil water ratio. And then we also have them do water chemical analysis, usually on the well. Okay.
What about mechanical integrity?
We don't do pressure tests. We do what's allowed by the regulations for dually completed wells.
And what does that consist of? I'm sorry.
We do the fluid levels, shots on the well, and the oil water ratio. And then we also have them do a chemical analysis of the water. So we compare going down the tubing compared to the water that's coming out of the producing side of the well. And that only works if there are different types of waters. And we'll see a difference in the water analysis if there's some cross-contamination going on, if there's a tubing or case or a packer leak.
Okay. And are these procedures in lieu of a pressure test?
I guess you could say that, yeah.
Okay. Interesting. And that you say is for 4 wells, basically?
We have 4 or 5, yes.
Can you tell me roughly what are the age of these wells? Do you know?
I think I'd say half are newer, half are older, but that's pretty vague. I don't recall the ages really of the wells.
Would any of them be of the age of this well or older?
Yeah, I can't say. I don't recall the ages of those wells.
Okay. So basically what I understand you're saying is that you were quite specific there in terms of the monitoring and reporting requirements you're looking to. You're quite specific about that. And you were saying, I guess, and I'm not trying to put words in your mouth, please, that was an alternative substitute for pressure testing in your judgment.
By the regulations, yes.
Okay. No further questions. Thank you.
And Commissioner Keither? Well, Mr. Morris, I don't think Commissioner Keen abided by his promise of one question there, but I'm going to ask you, you maybe one more. I should have asked it of Mr. Clock as well. And I'm struggling with how to ask it, but look, I read your testimony as basically saying, I agree with Mr. Sullivan. I'd have the exact same concerns, no additional concerns, but I'd have all the same concerns. And I wouldn't support an application with a wellbore design like this in my district. I mean, are you concerned that if we grant this application, there would be a flood or at least a few similar applications in your district? Or do you think this is unique and that's not really a relevant concern?
I don't think I would in my district. I can't speak for Kenny's area, but this well is completed somewhat differently than the ones in my district and under different conditions and for different reasons, maybe. And so I can't really answer that question.
If this application were approved, it strikes me that the staff isn't immediately gonna just lose all their concerns. They're not gonna say, okay, we agree, we were wrong. Is there any value in the commission saying, look, we find the facts of this case support granting this application, but we recognize, there's some concerns about how this well is going to play out over the next few years. And we want to see how this well performs and how the mechanical integrity of it performs for a little bit before we were to address future applications. I mean, do you see value in that, or do you think, gosh, it could be 1 or 2 decades, so
yeah,
there's not much value in waiting? Anything you could provide on that kind of random thought?
I think there'd be value in proceeding with caution with it. Like you say, in the event that, if we approve this one, there might be numerous other companies that want to do the same thing. One of our concerns is, of course, getting the packer back out of the well. Anybody will tell you the longer a packer is in a well, the higher risk there is of not getting that packer out.
Yeah.
And losing the packer in a well can sometimes be the death of the well. And we're spending a lot of money getting that packer out. And that's one of the things with this well. I don't disagree that what they're doing for monitoring things will tell you of a catastrophic problem with the well, but it won't tell you a small problem.
Yeah.
And small problems can lead to bigger problems sometimes.
Well, that's helpful. I know my question wasn't very artful. I'm just trying to balance a lot of different thoughts here and try to figure out a way forward, and what sort of future circumstances the staff might help the staff gather more information before we open any kind of floodgates, if that makes sense. So I appreciate your answer. I don't think I have anything further. Are there any more commissioner questions before I offer redirect? I'm seeing shaking heads. Mr. Marsh, any redirect?
Yes, thank you, Chair French. Case, how long have you been supervisor of the District 4 office?
2008.
And do you have an idea of how many of the dual completion wells have been permitted since you became supervisor?
I think there's been 2 permitted since I've been supervisor.
And do you, I mean, either of those wells or any wells in general have the same sort of completion that this well bore has?
No, those wells are, I think they're all disposing into the Arbuckle and producing out of Kansas City. And those zones are all within, a couple of 100 feet of each other. So they're much closer, not spread apart like in this well.
What about cementing? Is the cementing structure in the wells in your district similar to the proposed wellbore design?
And they're continuously cemented through the Arbuckle and Lansing, Kansas City zones and higher.
Okay, thank you. No further questions.
Mr. Schlatter, any recross necessary? Okay. All right. With that, I think we're at the end of your testimony, Mr. Morris. We thank you for your time. Thanks for hanging with us all day here, and you may virtually step down. Appreciate it. Okay, let me see where I'm at on my script here. Looks like we are ready for closing statements to the extent the parties want to make them. Mr. Marsh, would you like to make a closing statement?
Yes, thank you, Chair French. As I stated in my opening, and as Mr. Schlatters also stated, today's testimony was regarding 3 specific areas. 1, the ability of operator to establish and adequately demonstrate future mechanical integrity of the well if its injection application is approved. 2, the type and frequency of chemical inhibitors anticipated to be used in the dead zone and whether substantial evidence exists to find such agents will be effective. And 3, any other testimony believed relevant to the question of whether there is an unacceptable risk of environmental harm associated with granting operator's application and or whether such risk can be adequately mitigated. Regarding the first part with mechanical integrity tests, the Conservation Division has received a peer review from the Groundwater Protection Council with a recommendation to phase out dual completion wells due to the difficulty to conduct mechanical integrity tests. Staff has recommended that if the commission deems that the injection application submitted by Merit should be permitted, then Merit should be required to conduct a pressure test at the well as described in the commission's final order every 5 years. There's also a history there of Merit indicating that it is not opposed to conducting a pressure test on the subject well every 5 years, although it seems like that has since changed from whenever they made that comment. A lot of the testimony only considers doing a radioactive tracer survey test, but in combination with the fluid and gas monitoring, there's already been some kind of inconsistent numbers between the amount of water produced and the amount of gas produced. And then as Kenny testified, we can take the ratio measurements, but that doesn't necessarily test the casing and certainly doesn't test the casing the same way that a pressure test would. Also, you look at the regulation for permitting alternative tests, and it says that the alternative test, may be appropriate if the conditions are appropriate. So there's 2 parts to that where you have may. So as Mr. Letsky said, it means that it's permissible, but not necessarily required. And then if the conditions are appropriate, I think all 3 of staff's witnesses have kind of testified that the conditions present with this wellbore application don't necessarily provide the appropriate conditions for a radioactive tracer survey as a substitute for mechanical integrity tests. Moving on to the second part, the commission asked for supplemental testimony regarding the type and frequency of chemical inhibitors anticipated to be used in the dead zone and whether substantial evidence exists to find such agents will be effective. Staff does not believe that Mr. Moorhead was provided credible testimony regarding the proposed chemical treatment plan to mitigate the corrosiveness of the formation fluid in the dead zone. And whenever I say not credible, I think there's really two parts of that that go towards that. We talked about the specific gravity of the corrosion pellets, the CIP-25 pellets, based on the documentation that staff's been able to gather. It does not appear that these pellets would sink to the bottom of the packer or the bottom of the dead zone and effectively treat the dead zone. It sounds like maybe that can be mitigated by getting heavier pellets, but that hasn't necessarily been provided by the testimony here today. I think, you also have to maybe question some of the credibility whenever, Mr. Moorhead works for SGB Solutions, who is, has merit as a client. So there, as we kind of discussed at the very beginning, there's a substantial financial relationship there. So this isn't a chemical recommendation from a third party or hasn't been necessarily reviewed by a third party who is able to independently look at it and say, this is an acceptable work. I think that you have to look at the financial relationship there. And I don't know that we should be surprised that he's recommending that this is acceptable. Merit is paying SGB a substantial amount of money to say that the recommendation is appropriate. And I guess moving on to the third point or last point, the commission sought supplemental testimony relevant to the question of whether there is an unacceptable risk of environmental harm associated with granting operators application and whether the risk can be adequately mitigated. A lot of that's been focused on necessarily or groundwater or protecting usable water. And I don't know that the parties have necessarily shown that usable water is necessarily in danger. But I think the lack of being able to effectively demonstrate mechanical integrity at the well is an environmental harm. And I think, not being able to adequately treat the produced water in the wellbore would be an unnecessary environmental harm. Kenny talked about the number of spills that have happened on the lease over the past, several years. And while that's not necessarily directly correlated to this wellbore application, I think it's certainly something that needs to be considered before granting an application of this magnitude, as far as the amount of water per day that's going to be injected down this well and the pressure that the water is going to be injected at. Also, have concerns with, you look at the commission's regulations, and I know in the opening, Mr. Schlatter asked that the commission apply the existing regulations to the application. And I still keep getting hung up on KAR 82-3-406A2, which just talks about the tubing and packer requirements for injection wells going through tubing below a packer. And that regulation requires a packer run on the tubing to be set in casing opposite a cemented interval at a point immediately above the uppermost perforation or open hole interval. It sounds like Merit's willing to do a cement bond log, so maybe that issue can resolve itself, but we don't really know that information yet. And, as Jeff testified earlier, sometimes those cement bond logs can surprise you and you don't know necessarily what you're going to get from them until you actually get them, or have one done. That regulation also requires the annulus between the tubing and the casing to be filled with a corrosion inhibiting fluid or hydrocarbon liquid. That's also an issue here, right? Because you have producing fluid that's entering the well bore. And so it's like, can we effectively treat it? Can we not? And I don't know that there's really any, whenever I ask questions of Mr. Moorhead, it's not that we're turning this fluid into a corrosive inhibiting fluid. It's hey, we're trying to address the corrosion concerns in the fluid. And I don't know that those are necessarily the same thing. But I think that is a concern. And I asked, Mr. Lahutsky if there's any exception for duly completed wells not having the tubing and packer requirements applied to them. And maybe there's an argument for that, but it seems really strange to have an injection well that wouldn't have tubing and packer requirements, and there's certainly no exception laid out in the commission's regulations. So I think that about covers kind of staff summary of how the position it takes on things, and the way that it kind of reviews maybe the unacceptable risk of environmental harm aspect. I guess the last thing I was mentioning is, you have 3 district supervisors and professional geologists who are saying that this isn't the best idea. And, I think that definitely carries some weight and something that the commission should consider. Thank you.
All right, thank you, Mr. Marsh. Mr. Schlatter.
And eventually, all my salutations and grace are being lost in the ether, but thank you, and it's been a long day. I appreciate everyone's time and attentiveness to this matter. I mean, I think the upshot here is staff wants these phased out, and that's, maybe some of that's based on these ideas or speculative concerns. Some of it's on this paper that's now 4 years old. But this isn't the place to phase out regulations. This is a hearing where regulations are applied. There's a legislative process to phase out regulations. If this peer review was taken seriously, I think we would have heard about it in 2021, 2022, 2023. Maybe now. We haven't. It seems more like a weapon to blunt this application than it is actually a legitimate concern. And these regulations that the commissions have drafted have meaning, and the meaning of those regulations is quite clear. If we were to take a hyper literal interpretation of the regulation 407, then the only casing integrity that could be required, the only mechanical integrity testing that would be required is that monitoring. That's the part that says duly completed wells. Everything else wouldn't be necessary. Merit is proposing to go above and beyond that. And I believe that these testing will show a casing leak. And I think one thing that we kind of have lost, and maybe lost from the first hearing, is the likelihood of a casing leak here, as the cement bond log will demonstrate, is in a very narrow zone. There's nowhere near fresh water that is indeed a zone used for disposal already. So even if it did manifest itself, there is no environmental risk whatsoever. Now, on the flip side, to require a pressure test is to require $25,000 of expense that probably wouldn't get incurred. What will happen if that is a requirement is this gas zone will be plugged off and will be lost forever, and the well will then be utilized for injection. That is and will cause waste, no doubt about it. What Merit is proposing gives us the opportunity to salvage those gas reserves and continue to, and implement an injection program that has been proved to recover, I believe, millions of barrels of oil, and they believe it will cover tens of thousands more. And so permitting this application does indeed prevent waste. It does indeed protect correlative rights. And not one person testified today in any, coherent fashion that pollution was potentially at issue based on the strict construction and integrity of the well. Now, we keep talking about this pressure test like it's some magical way to prevent casing leaks. It's not true. Pressure tests can only identify a casing leak. That's what the monitoring does. Apparently, that's what they're doing in District 4. I was surprised to hear that, but it's adequate there. It should be adequate here. I believe we keep going back, it's the tracer testing, it's the pressure testing. What Merit's proposing is a suite of testing. A radioactive tracer testing to demonstrate the tubing has mechanical integrity, that the packer has mechanical integrity, and that the water is going to the interval. It's not channeling anywhere. That's what that does. The monitoring does the rest, and that zone, that casing zone, the production casing zone, where every producing well can and does get a casing leak from time to time, and those casing leaks are identified just the way the monitoring suggests.
Now, the chemical program, on the other hand, I believe to be comprehensive, well thought through. It's nimble. It provides for monitoring in the event that it's not effective. Mr. Moorhead testified it's widely employed and effective throughout this area. And that's what they're hired to do, is to provide that service. If they weren't providing a service that was successful, they wouldn't have a company. And they're indeed have quite the company. Kelsey mentioned that his testimony wasn't credible, but Mr. Sullivan said that it was, and he was the only person to ask that question. The idea of some of these things that staff is asking for just aren't possible, like filling the production string of this well with corrosion inhibitor is not impossible if you want to salvage the gas zone. That just cannot happen. The cost of doing this well intervention that they're demanding is, I think, and Chair French pointed this out, the incremental benefit is so far outweighed by the cost and the risk that Merit's not willing to do it. That's how significant it is. And I think that's important. So with that said, I do believe the application should be granted. I believe it not only satisfies the regulations, but exceeds them. The issue of the bond log was already a requirement of the final order. Merit's not backing off of that. It will follow through with the bond log. I believe the chemical program, as recommended, which is proven to be nimble and adequate to not only prove that it works, but is effective in other wells, should be adopted, and that the mechanical integrity, the suite of programs and monitoring that I just identified, should be adopted by the commission. And that's all I have.
All right, thank you, Mr. Schlatter. Let me ask at this time whether the parties have any post-hearing issues that we need to address before we conclude the hearing. I'm not seeing anybody jump off of mute, wave their hands. Anything from the commissioners? All right, if there is nothing more, this concludes our hearing in this docket. At this time, we will close the record and adjourn. Thank you all for your participation, and hope you have a good rest of your day, what little there is of it. Take care, everyone.
Thank you, commissioners.
Thank you.